Oh, let me get this music going. Okay, we want to do video. Let's start this. Do the video. Only 7. Okay, start. It's probably only an hour-long course. Start course.
Hey everyone, my name is Christopher Reese, and welcome to my course, Law, Ethics, and Security Compliance Management. I am both a Pluralsight author and also a senior enterprise ops leader, and over the past 20 years, I've trained over 200,000 students around the world, as well as managed teams, both local and remote, that have served millions of customers around the country. So one thing is for sure, ensuring your company complies with all local laws and regulations, as well as adheres to internal policies and procedures, is a critical component to long-term success. Doing so in an ethical fashion and building a security and compliance mindset into the culture is something that every leader needs to develop, regardless of position, industry, or location. In this course, we're going to develop a deep understanding of the need for compliance, what that's comprised of, and how ethics and compliance, or the lack thereof, can impact your business either positively or negatively. Some of the major topics that we'll cover include reviewing the major regulations facing most corporations, things like HIPAA, GDPR, CCPA, SOX, and so forth. If those don't ring a bell with you yet, don't worry, by the end of this course, you'll be very familiar. Also, intellectual property laws, various types of liability, and how infringements are handled. We'll talk about import-export controls and some of the major legislation impacting certain industries. We'll also cover ethical considerations when dealing with employee communications, monitoring employees, customer data, and also intellectual property. And lastly, we'll review several enterprise security frameworks, such as the one from NIST SP 800-53 and several others. By the end of this course, you'll have a good understanding of how to ethically ensure security compliance within your organization, with vendors, contractors, and with those with whom you do business. Before beginning this course, you should be familiar with security fundamentals, such as Security Plus, and the courses in the security management path. From here, you'll feel comfortable communicating and presenting to executive leadership and crafting your own ethical path to compliance throughout your organization. I hope you'll join me on this journey to integrate compliance into your company with the Law, Ethics, and Security Compliance Management course here at Pluralsight. Hey everybody, welcome back to Pluralsight. I'm your instructor, Christopher Reese. Welcome to this course on Law, Ethics, and Security Compliance Management. In this course specifically, we'll talk about global privacy laws and why it's extremely important that we maintain compliance and understand the potentially significant implications and ramifications if we don't maintain that compliance, both regards to brand reputation, financially, litigation, up to and including prison time. So it's important that we pay attention to the information here. So let's go ahead and get started. In this module, we'll be talking about, as I mentioned, global privacy laws, some of the current challenges. We'll talk about laws that can influence and affect information technology security, such as the Graham-Leach-Bliley Act or the GLBA Act. We'll talk about HIPAA. We'll talk about the HITECH Act, Sarbanes-Oxley or SOX. We'll talk about GDPR, CCPA, and also licensing, such as EULAs, equipment-specific and site licenses, and of course open source and the new General Public License or GPL. So all extremely important information, some admittedly a little more exciting than others, but all extremely important, both from a trust perspective, brand reputation, customer loyalty, but also litigation, fines, penalties, and so forth. So let's go ahead and dig in. All right, so before we get started, let's ask the question, who should watch this course? Well, perhaps the better question should be, who shouldn't watch this course? I'd like to say everyone should watch this course simply because the information and the ramifications of not actually complying, both from an ethical standpoint and also a financial or legal implication standpoint, can be quite impactful to an organization. So compliance officers and anyone working within compliance regulations, they should watch this course if they're not already familiar with the content, or even if they are, it's a good refresher because things constantly change. There's new legislation, there's new regulations that get introduced and so forth. HR and governance. People within these groups, even if they're not specifically dealing with regulation or a specific component, all of these things affect them in one way or another. We have to make sure that we're...
One sec.
or abiding by the rulings, some of which can be very minute, and there's a lot of details and nuances within some of these regulations, and you may say the GDPR as an example. Well, I'm not in the UK, so it doesn't affect me. Well, that's not necessarily true. Those things have global reach, which is why this course is on global privacy laws. People in the UK obviously are covered by GDPR and other parts of the world by their specific legislation and regulations. But if your company does business with people that live in those regions, or your business affects somehow the people that live in those regions, you may not necessarily do business with them directly, but your business affects them in some capacity, well, then your company can be held accountable under certain parts of these various laws. So it's important that we familiarize ourselves with those nuances. IT operations and IT managers. This is a bit of a no-brainer. The systems that we maintain must be in compliance. So it's important that folks within IT, again, not necessarily just security folks, but IT operations folks, IT managers, executives, and so forth should be very familiar with the content within this course. And then the no-brainer, IT security managers. We want to make sure that we're maintaining security compliance, that our data is safe. All of these things combining together, if we all work together, everyone's on the same page, and everyone is actually doing their due diligence and making valiant attempts to secure, protect, and keep data away from prying eyes, not keeping data longer than we need it, and so forth. All of those things work together to satisfy the requirements of most pieces of legislation and can help keep your company out of financial duress, litigation, and things along those lines. So at the end of the day, the takeaway is share this course with team members and folks responsible for data governance, compliance, and security. And really, keep in mind, these things are really everyone's challenges, everyone's mandate. We all should be doing these things. So let's go ahead and take a look at the challenge. All right, the challenge is the global nature of the internet can cause communication and expectations of privacy to vary widely throughout different parts of the world, as you can imagine. Behavior that is totally acceptable in one part of the world can actually be a capital offense in another. So the nuances of these laws and these regulations, especially if you travel globally, are very important to keep up on and make sure that you're familiar with. Okay, so when we're talking about doing business in a global economy, a few things to keep in mind. The United States used to traditionally set the tone for data privacy laws. Up until recently, the last 5-10 years or so, the US more or less led that initiative. However, other countries have stepped out and taken the lead, specifically countries throughout the European Union. More restrictive regulations aimed at consumer privacy and protection, so a lot more geared towards privacy of the consumer. The whole data protection laws and regulations that are coming out both in the UK, or the European Union, and also the US and other parts of the world are now, again, geared towards protecting that consumer information or that customer data. And the onus is being placed on the organizations or the companies to make sure that that data is protected. So companies must comply with the laws of each country in which they do business. And this is where it can get a bit cumbersome because the laws will change or vary from region to region. So they may be very restrictive in one area, not so restrictive in the other. But as you can imagine, the best bet will be to comply with the most restrictive policies. That way you ensure that you're covering all bases. So let's take a look at some of the privacy compliance challenges. So we have a few things to keep in mind here. Data security. Data security requirements come from all angles: data privacy laws, cybersecurity regulations, trade secret law, customer-specific contracts, consumer protection statutes, all of which can vary depending upon jurisdiction, location, etc. So these things can potentially overlap depending upon where you do business, or in some cases may be slightly contradictory. So it's important to thoroughly understand all the regulations in the areas in which you do business. Deletion of data is another big one. Understanding what data a company actually has in its possession, where it resides, and how long to retain that data is a major challenge. As you can imagine, as companies grow and we have terabytes upon petabytes, potentially exabytes of data, and that data is accumulated over a large period of time, user files, application files, data files, logging, and so forth, that grows and grows and grows. We have separate environments within our infrastructure. We have production, we have testing, dev, QA, and you may have multiple copies of that data. So as things grow, data grows, and a lot of times, in a lot of situations, we don't understand, at least at a macro level, what all that data actually is. Because as I mentioned, there are copies of copies in many instances. So we may delete the primary copy of that data, but there's like 5 or 6 or 10 other copies in lower environments or in test and dev, QA environments that exist that we may not necessarily be fully aware of. So data governance is a big one. Also, documentation. Keeping up with requirements, especially with global companies, as I mentioned, is becoming increasingly complex. Requirements between various countries and even between states, local, federal, etc. Again, they can sometimes overlap or even become slightly contradictory if you don't understand the nuances of those specific regulations. Some other ones to keep in mind: ethics and compliance. Collection of massive amounts of data from an ever-increasing number of sources that can create, as you can imagine, privacy and also security challenges. Big data aggregation and analysis can create PII, or person-identifiable information, from disparate sources. What does that mean? Well, it means I may have pieces of information that by themselves don't necessarily identify someone. But when I start doing data aggregation, data analytics specifically, I can start pulling all these different pieces together and build a profile of someone that is actually very, very accurate. So those individual pieces of information now become very telling of who a person is when looked at the whole body of information. Also, inadequate data management, defining who actually owns the data, who's the data owner, the governor, and so forth. This also includes data lifecycle, how we delete, how we manage, and so forth, how long that data is processed, analyzed, and secure. As you can imagine, this entire conundrum becomes more and more complex. And then also, insecure infrastructure. So data environments are often designed for speed or for scale, but not necessarily for security. In many instances, security is a bit of an afterthought, as we know. It's not necessarily designed with that in mind from the beginning. A lot of companies with their dev and engineering departments, they kind of view security as, quote unquote, no as a service. Or as I sometimes say, putting the no in innovation. It's not necessarily true. And that's changing, luckily. The perception, at least, is changing. Security, as we know, is an extremely important part of the entire ecosystem, and it has to be thought from day one. It can't be an afterthought. It can't be a bolt-on. So the insecure infrastructure is creating major challenges because we now have to go back and try to retrofit a lot of these environments. IoT devices, the Internet of Things devices, posing a major challenge because these things, again, are a lot of times consumer devices, not necessarily designed with enterprise-type security in mind. When you bring those devices into an enterprise, you start to really crack fissures, if you will, in the security infrastructure, and basically you're kind of fragmenting the security posture. Okay, let's go ahead and take a look at a few examples of regulations that may affect your ability to do business depending upon what region you do business in, where your company resides, where your customers reside, and so forth. So, starting off, the Graham-Leach-Bliley Act, the GLBA, and we'll cover each of these in more detail in just a few. Also, the Health Insurance Portability and Accountability Act, otherwise known as HIPAA. Health Information Technology for Economic and Clinical Health, otherwise known as the HITECH Act. Also, Sarbanes-Oxley Act, otherwise known as SOX. And then one of the newer ones that's been getting a lot of press lately is General Data Protection Regulation, or GDPR. And then a bit of a US version of that regulation, the California Consumer Privacy Act, or CCPA. So to start off, the Graham-Leach-Bliley Act, GLBA, also known as the Financial Modernization Act of 1999, and what this does is specify that financial institutions must secure any and all personally identifiable information, or PII. So tax agents, mortgage brokers, banks, credit unions, etc., etc. And then there are a few sub-bullets, if you will, within that regulation that provides additional regulations. As an example, the Safeguards Rule. This stipulates that financial institutions must implement security initiatives to protect confidential information. The Financial Privacy Rule. This stipulates that financial institutions must provide a privacy notice to the customer, both when the relationship is established and on an annual basis. So you may notice that you'll get pop-ups or information from your banks and your financial institutions once a year saying, hey, we've updated our privacy rules, or here is a reiteration of our privacy notices, just so you're aware. And then we have pretexting protection. This prohibits access to personal private information without proper authority. What this is supposed to help with is things like social engineering, where a hacker or a bad actor would call into a company, pretend to be someone in the know, or someone that has a legitimate interest for information, and ask probing questions to try to get information out of the unsuspecting victim. So this type of regulation helps put some guardrails around that, some training, and also just awareness around the fact that these types of things need to be protected, and they need to be protected at scale, right, throughout the entire company. Next, we have the Health Insurance Portability and Accountability Act, otherwise known as HIPAA. So this is also known as the Kennedy-Kassenbaum Act, implemented in 1996. And the one that we are concerned with, or probably most applicable, is Title II, Preventing Healthcare Fraud and Abuse, Administrative Simplification, Medical Liability Reform. Right, so that's a bit of a mouthful. What this basically has is two main sections. We have the Privacy Rule, which defines patient medical records, or protected healthcare information, PHI, and then also the Security Rule. The Security Rule defines security measures required to protect electronic protected health information, or EPHI. Now, without digging too much into any one of these specific regulations, because quite frankly, each one of these would be probably a couple-day course in and of themselves to really fully understand. In most cases, very complex. But the thing you need to understand is, if you're dealing with these types of situations and you're doing business and you're maintaining health records or financial information, or you're dealing with business outside of the country, it behooves you to really dig in and start understanding the nuances of all of these different regulations and how they apply. There are rigid sentencing guidelines. Up to criminal prosecution can result for violating HIPAA rules. Right? So very important that these things are followed to the letter. Next, we have the HITECH Act. So the HITECH Act is the Health Information Technology for Economic and Clinical Health Act. So it became law in 2009, and in 2013 provided updates to HIPAA based upon the HITECH Act. So that included additional reporting requirements around significant harm, and also removed the requirement that there needed to be actual proof that harm was done. So at this point, it's just possible to prove that harm could have been done, and that would satisfy the requirement. Before this, you had to actually prove that harm was done. So now, as long as it's reasonable to believe that harm could have been done, the regulation provides for penalties and so forth. Additionally, it also added business associates of parties handling medical information or medical data are now included. So not just the primary business, but business associates are now covered under this HITECH Act as well. And then the length of time that PHI, right, protected health information, is protected was shortened from forever, which is, as we know, quite a long time, down to 50 years, which for the most part is the majority of a human life, or at least a human adult life. A few high-tech considerations, right? So willful neglect can result in significant penalties. And we're talking up to $250,000 with repeat or uncorrected violations, extending up to $1.5 million. So not an insignificant amount of penalties for noncompliance, right? Very important that these things are followed as much as possible. Also, penalties can extend, as I mentioned, to business associates. So as a covered entity, you must get assurance from any business associate that you do business with, or whom you share EHR or EPHI, that they will protect that data. If not, you can be held liable, right? HITECH Act considerations. Very important to understand the nuances of all of this. And then also breach notification. Patients must be notified of any unsecured breach. If 500 or more patients are impacted, Health and Human Services must also be notified. The media must be notified, and so forth, right? So breach notifications are not optional. It's a mandatory thing that must occur if patients are in fact impacted. Okay, next, let's talk about the Sarbanes-Oxley Act, or SOX. The actual title of the regulation is the Public Company Accounting Reform and Investor Protection Act of 2002. Sarbanes-Oxley, names of the people that actually presented or introduced the legislation, created primarily to protect investors and improve the accuracy and the reliability of corporate disclosures around security laws, so on and so forth. All right, so the CEO and the CFO are both required to certify financial reports. It provides for greater accountability and holds them accountable for inadequately protecting IT systems responsible for financial reporting. So after such corporate meltdowns and debacles such as the Enron fiasco of years ago, Sarbanes-Oxley was designed basically to prevent those types of things from being able to happen again. So as I mentioned before, if you're involved in these types of corporations or companies or organizations that are around finance, investing, securities, and so forth, the people that are responsible for that specific part of your organization, I'm sure are very familiar already with the Sarbanes-Oxley Act. But if you're not in that scope specifically, but within that company, I still would recommend that you familiarize yourself and really dig into the nuances of these acts. And that should go enterprise-wide or company-wide so that everyone is operating off the same sheet of music, if you will. Everyone is driving the same objectives and also making sure that the accounting is done properly. When the books are actually messed with and accounting is not accurate, there's a huge potential for investor loss. So this type of legislation is designed to help prevent that. Okay, now when it comes to SOX compliance, what are the main areas that the regulation is looking to cover? Well, first off, maintain data integrity and confidentiality. In other words, keep the data safe and secure. Now remember, SOX compliance, the CEO and the CFO need to sign off that these controls are in fact in place, that they're there, they're documented, they're demonstrable, we can show that they actually exist, and they actually are protecting the data, keeping it safe and secure. This deals with financial systems, access to files, access control lists, auditing who can access what, and so forth. Also, track any attempted security breaches, and also what are the actual resolutions. So what happened and what did we do to prevent it or mitigate that risk going forward? Next, maintain event logs and make available for independent audit. And that's one of the key takeaways. This is not one of those things where you just have a checklist and you're checking the boxes, you put it into a folder and put it on the shelf. These things need to be able to be audited every so often, and they will in fact be audited every so often. And if those controls are not in place and they're not demonstrated that they actually are working and functional, then you can be found not in compliance. Right? So as I mentioned, document that compliance and be able to show the prior 90 days. And since we don't know when the audits are actually coming, what does that mean? Well, that means we need a running log of the previous 90 days pretty much at any point in time. So the moral of the story, friends, is keep the systems functioning, make sure they work, make sure they're documented, and also demonstrable. Make sure logging is in place, we track any attempted breaches, we know who's trying to access what files and when, who they are, and if they try and fail, that's logged as well. So all of these things have to be in place and be able to be shown at a moment's notice when those auditors come knocking on the door. Now, as you can imagine, the SOX regulation has a number of sections, each pertain to a specific area. We'll cover 3 here that I want to call your attention to. Understanding this is a high-level overview, we're not digging deep down into the weeds, but there are some things that you need to be aware of and familiar with. So Section 302, it's required that we have quarterly certification of all financial reports. The responsible parties are the CEO and the CFO. They also have to make sure that there is disclosure of all known control deficiencies and also disclosure of acts of fraud. So if there's something going on, it needs to be documented and disclosed and then signed off on by the CEO and the CFO. They can be held personally responsible if that is not fulfilled. Next is Section 404. That deals with management annually certifying internal controls. Again, we need to make sure that the controls that are in place are actually there and it's documented that they work day to day. Also, an independent accountant or accounting firm must attest to this report, right? So it needs a third-party verification. Also, quarterly change reviews. So anything that's changed in the environment, right, quote unquote, near real time, those things need to be reported and attested to and also verified by an independent auditor. So the responsible parties for that would be management. And then, as I mentioned, an independent auditor. Then we have Section 409, which deals with monitoring operational risks. So anything that may be viewed as an operational risk, and again, we're dealing with financial systems here, that needs to be discussed and disclosed. Any changes in the environment that are material in nature, meaning significant, need to be reported as well. And here, under Section 409, we need real-time reporting, right? So real-time implications, anything that's changed of a material nature that may have a significant impact needs to be reported and filed within 4 days. Same thing as Section 404, the responsible parties are management and an independent auditor. So just to give you a brief idea of why SOX regulation was created, here's a very small, and I mean a very tiny smattering of some of the corporate greed, the corporate misgivings that were going on in the early 2000s. So right at 2000, the dot-com bubble burst. A lot of these dot-coms that sprang up had these massive valuations worth billions on paper, dried up almost overnight, and a lot of people lost savings, lost their jobs, houses, and so forth. So it was a bad time to be a dot-com. Also in that time, at 2000, Xerox was found guilty of falsifying financials, boosting income by $1.5 billion. And in doing so, they're duping investors, they're making themselves look more profitable than they are, and basically cooking the books. In 2001, Enron did something similar, also boosted profits and hid debts of over $1 billion. So again, why do they do that? They do it to make themselves more profitable, to gain investors, to gain market share, and so forth. Bilking investors and people that work hard for their money out of millions upon millions of dollars, the investors left holding the bag at the end of the day. 2002, the Tyco CEO was indicted for tax evasion, basically shipping millions of dollars of artwork to one location while shipping empty crates to another location to make it look like he was receiving the goods in a state where there was not as much tax to be paid. So he was basically doing tax evasion, in addition to spending millions upon millions of dollars on parties and lavish events and so forth that were not really business appropriate. So ultimately, it was over $100 million that was bilked from the company. And again, that company went down in flames. 2002, Merck did something similar. It recorded $12.4 billion in consumer payments that it never collected, just for greed. And at the end of the day, again, the investors are the ones that pay the price. And then also in 2002, WorldCom overstated cash flow by booking $3.8 billion in OPEX as CAPEX. So all of these things, as you can see, were kind of rampant, running wild in the early 2000s. So the SOX bill was introduced and the regulations enacted to help prevent this very type of corporate misgivings. And again, this is just a small smattering of a dozen or more incidents like this that took place during that time period. So the SOX regulation has been very beneficial as far as holding corporate executives accountable for their actions. Next, one of the ones that gets a lot of attention nowadays is GDPR, or the General Data Protection Regulation. So it's a privacy and security law that originated in the European Union in May of 2018. It imposes obligations onto organizations anywhere. So this has reach beyond just the EU, so long as they target or collect data related to people in the EU. So again, just because you're located in the United States or maybe somewhere outside of the European Union doesn't necessarily mean you are not impacted by GDPR. So what type of data does the GDPR cover? Well, it provides individuals, which are known as data subjects, more control over how organizations process or control the processing of their data. Such things as names, locations, patient data and health records, email addresses, photos, and so forth. Essentially any data that could be used to identify a living person. So let's look at some GDPR key terminology. So when it comes to personal data, let's say we have Sally here, anything that could identify her, such as names, ID numbers, dates of birth, email addresses, online identifiers, photographs, religious beliefs, location data, and a number of other things, anything that can be used to uniquely identify her is covered under GDPR. So keep those things in mind when you're collecting data from customers, right? Do you have a legitimate use to know all of these things? As an example, are you collecting someone's date of birth, but you never have any need for that data? You're not going to wish them happy birthday. You're not going to send them a birthday card. It's not used for loyalty purposes or anything. Well, that might be ruled then as an unnecessary piece of information, and you could be subject to regulation under the GDPR. Right? It has to be specific, use has to be relevant, has to have a purpose for being collected and also maintained. Some additional key terminology. Processing. So processing is any operation, whether automated or a manual process, that is performed on personal data. A data processor is responsible for the processing of personal data on behalf of what's known as a data controller. And a data controller is the person or the thing that determines the purpose and the means by which personal data is processed. Now, as far as GDPR is concerned, there are 6 data processing principles, and these are what I talked about before. When we're collecting all of this personal information, we need to make sure that they fall under these data processing principles. So there needs to be lawfulness, fairness, and transparency, right? We have to have a lawful or a legal reason to actually gather that information. Purpose limitation, right? A specified use and explicit use, a specified limit of time. Data minimization, we're only collecting what is necessary. As I mentioned before, if we're collecting someone's date of birth and we have no need for that data, then why are we collecting it, right? And if we can't demonstrate and document why we need that data, then we can be subject to those regulations, right? Also accurate and where possible, kept up to date. So if we're gathering someone's information, they have the right to actually update their own information. They have the right to have access to it and see what we're keeping on them, but also it needs to be kept up to date if at all possible. Also, storage limitation, keep only as long as necessary. If we're keeping data for an indefinite period of time, we could be liable to GDPR regulations. If we only need that data for 6 months, then only keep it for 6 months and delete afterwards. More importantly, or most importantly, we have to document and be able to show that that data is actually being deleted, right? We just can't say it. We actually have to have processes in place and documentation in place to show that. And then integrity and confidentiality, just like we have for any security tenant, right? The triad: confidentiality, integrity, and availability. Well, same thing here. We need to make sure that the data is kept secure. We have to demonstrate via documentation and the systems we have in place that we're making a best effort to actually keep that data secure. So if we fail any of these 6 tenets, right, these 6 data processing principles, then that company can be held liable under certain parts of the GDPR. Next, we have 6 legal grounds for processing personal data, right? We have to make sure that we have that person's consent. It has to be explicit, and they have to be able to opt out just as easily as they opted in. It also has to be a legitimate interest. We need to be able to demonstrate and document that we have a legitimate interest to that data. Is there some contractual obligation that we process that data? And then a legal obligation. Are we legally bound to either gather and process that data? Public authority, right? This one goes without saying. Now, a lot of the things with the GDPR, public authorities aren't necessarily bound by those same underlying principles. And then vital interest. Basically, is it a matter of life and death? So whenever a company processes a customer's or a user's data, it has to really fall under one of these 6 legal grounds as to why they're processing that data. Consent, legitimate interest to some type of contract, a legal obligation, you're a public authority, or it's a vital interest, right? A matter of life and death. If you can demonstrate, and again, this all has to be demonstrated and documented and can be subject to audit, of course. If one of those 6 things are being addressed, and typically it's going to be the top 3 that you'll see: consent, legitimate interest, or some type of contractual obligation. Most companies will utilize those 3 as one of their legal grounds for processing. Then you've met, at least on the surface, the grounds for GDPR processing of data. Now, what happens if GDPR compliance is not met? Well, I'm glad you asked that question. The GDPR provides for significant fines for noncompliance. There's 2 tiers of fines depending upon the type of infraction. All right, so let's take a look at these. GDPR penalties, there's 2 tiers, as I mentioned. A less severe infringement can go up to 10 million euro or 2% of the firm's worldwide annual revenue, whichever is higher, right? Not whichever is lower, whichever is higher in this instance. The second, more serious or more egregious infringements can result in fines of up to 20 million euro or 4% of the firm's worldwide annual revenue, whichever is higher. So it can be, as I mentioned, very significant. So as an example compliance scenario, here we have Wired Brain Coffee, which we all know and love. Wired Brain Coffee operates in the EU. They have customers there. And what happens is Wired Brain Coffee went ahead and collected data on roughly 75,000 customers in the UK. And through the course of their processing, they didn't really think too much about the GDPR. They didn't necessarily document what they're doing, how they're doing it. They didn't make provisions to really put into place all the things necessary to be in compliance. So they fail to obtain consent and also fail to make it easy to opt out of their data collection processes, right? So that's a no-no. So then they fail to adequately protect this data as well. Encryption, as an example. They didn't put the systems in place necessary to make sure the integrity and the confidentiality of their users' data was maintained. And as a result, they were audited and ultimately fined 2.5 million euro, or 4% of its global revenue of 50 million euro. So a very significant breach here, a very significant failure in their systems resulted in a pretty hefty fine. And if you think about it for a moment, it may have cost maybe half or a quarter or a tenth of that to put systems into place that would have kept them from those fines. And more importantly, or at least as important, they lose customer confidence, customer trust, brand reputation, consumer or investor confidence. So all of these things are kind of intangible, but they have long-lasting effects. It takes quite a while to gain someone's trust, but it's very, very easy to lose that trust. Next, let's briefly talk about the Brazilian version of the GDPR. Now, I won't pretend to be able to pronounce this one. My Portuguese is not where it should be, so I'm not going to butcher the name, but let's just go with the acronym LGDP. And basically, it is set to take effect in August of 2020. Key provisions of this regulation closely mirror the EU's GDPR. Several key distinctions, however. One example being that consent requirement is considered waived if the data subject has manifestly made public, in quotes, their personal data. So if that data is readily available on the internet or somewhere public, and they've made that data available, then it's considered to be waived, or that is a distinction from the GDPR. Since this actually hasn't taken effect yet, I'm going to just briefly touch on it, but I do want to make you aware that there are other countries within the world that are looking closely at the EU's GDPR and are using that as a model to mirror their own data protection regulations and data protection laws. Now, just like the EU has the GDPR, there's the Brazilian version, and other parts throughout the world are using the GDPR as a template for their data protection privacy laws. That also is occurring in the US as well. One of the more popular ones to gain attention recently is the California Consumer Privacy Act, or the CCPA. It was enacted in 2018 and took effect January 1 of 2020. And what this does is create new consumer rights regarding access to, the deletion of, and the sharing of personal information collected by businesses. For all intents and purposes, very closely mirrors the GDPR. The CCPA and the GDPR, they are separate legal frameworks. They do mirror each other in certain aspects. The CCPA is separate from the GDPR and has a different scope, different definitions, and in some cases, different requirements. Compliance is required under certain conditions, right? So if a business has an annual gross revenue of over 25 million, if that business buys or sells personal information of over 50,000 consumers, 50,000 plus, that could be households, devices, and so forth, or if that business earns half of its revenue selling consumers' personal information. So if a business meets any one of those three criteria, then they are subject to California Consumer Privacy Act regulations. So a summary of the rights provided by the CCPA. So the right to know what personal information is being collected, used, shared, or sold, both as to the category and the specific piece of personal information, right? So it gives users, consumers, access in much greater detail to what companies are actually collecting about them, how they're sharing it, how they're using it, and so forth. So also the right to delete personal information held by businesses and by extension, a business's service provider. So the right to be forgotten, if you will. Also, the right to opt out of sale of personal information. So consumers are able to direct a business that sells personal information to stop selling that information. And businesses must also provide children under the age of 16 opt-in consent, right? They have to actually get that specific consent. If the child is under 13, then they need parent or guardian consent, right? So that is very specific and it helps to protect children online from marketing, data gathering, and so forth. And then also the right to non-discrimination in terms of price or service when a consumer exercises a privacy right under the CCPA. Meaning, because I opt out of something or I say you can't gather this information on me or I want you to delete a specific piece of information on me, you as the business can't charge me more, you can't treat me differently, you can't do anything different than you would anybody else. The fact that I opt out or say I don't want a specific thing done to me, as long as it falls under the CCPA, you can't basically take action or retribution against me. Okay, let's go ahead and switch gears here and talk about something that's extremely riveting. It's going to have you on the edge of your seat, and that is licensing. All right, well, maybe not so much, but an important thing to understand nonetheless. So licensing is an agreement between licensor and licensee to allow the use of something, in quotes, to install software, make use of a patented invention, watch a movie, so on and so on. In other words, permission to use someone else's property in some capacity. So here's an example of a EULA, or an end user license agreement. Here happens to be one that I did a screen capture of a utility program that I installed just the other day for my concept rower. I needed to update the firmware, so I had to download a piece of software, install it, and of course it brings you to an end user license agreement, which no one ever actually goes through and reads, but it's there, and it creates an agreement between the licensee and the licensor. So the end user license agreement protects both software author and also copyright holder from liability. Basically, it removes any liability in the event that the software results in harm or loss to the end user. So it basically says, hey, if you use this software, you understand that it's an as-is arrangement. If it does some type of harm, crashes your system, destroys your computer, what have you, we're not held liable for that harm. To build upon that, we have equipment-specific and also site licenses. The license itself can be equipment-specific for a single user or an individual, or we can have it extend out to one site, physical or virtual, or it could be a combination of client and site. So depending upon how that agreement is structured, it could be simply for one person's use. It could be for one site. Like say, for instance, you have an enterprise that has multiple locations throughout a specific state, location, maybe even throughout the world. You may have the right to use that specific piece of software or that thing, right, that product, at one physical location or one virtual location only, or it could be enterprise-wide where you could use it at any location, or it could be a combination of client and site, right? So it just depends on how it's structured. Some additional license considerations. Does it define a specific location, physical or logical? Because that can be a distinction, or that should be a distinction that you should understand, I should say. Because if, in fact, as I mentioned, if it's only for one location, and you now copied or dispersed that to all of your locations, well, then you're in violation of that agreement, and it can be basically viewed as software piracy or some type of theft from the actual owner of that product. Also, does it limit the number of users, total or concurrent? If you have a license for 5 users and you just go ahead and disperse it to 500 users, right, as you can imagine, that's in violation of that agreement. And then also, how long is the license granted, and does it auto-renew? So is it for a specific period of time, maybe 6 months or 1 year or 2 years, what have you? And then at that point in time, does it auto-renew? So again, something to keep in mind, especially on the finance side, if that software renews every 1 year or 2 years or whatever that agreement is, 2 years down the road, you get a bill for that auto-renewal, it's good to understand what's coming down the pike. So failure to comply could result, as I mentioned, in fines or litigation, because the reality is it's similar to using pirated software. So it's very important to understand that that license that no one ever reads actually means something, and it's important that you follow that to the best of your ability. Otherwise, the owner of that product, the owner of that software, what have you, could do a true up, quote unquote, and say, okay, how many copies do you have in use? And if you're in violation of that agreement, they could say, okay, well, you're licensed for 5, you're using 500, here's a bill for the other 495 that you're using without my permission. Trust me, that's not something you want to have land on your desk. It doesn't make for a very good day. Okay, next, let's talk about open source and the new General Public License, or GPL. Now, the picture you see of the antelope here is actually a GNU, or GNU, I'm not quite sure how to pronounce it, but basically that's where the term came from, and that is actually the icon for the GPL license. So GPLs are not a contract per se, it's an agreement. For it to be a contract, it would need the following: an offer, an acceptance, and consideration. So this is basically a license that basically states any derivative works created under a GPL must remain under the GPL. So this is kind of the opposite of an end user license agreement, where it's a closed source software. The GPLs apply to open source software. So you can create a piece of work, license it under the GPL, and then make it freely available to other people. Not necessarily free in the sense that it costs no money, but free in the sense that they have the freedom to modify that how they wish. So they can modify that however it suits them. But if they then fork that software or create some type of derivative product from that software, it also needs to be licensed under the GPL. So they can't make it more restrictive. So every time it forks, every time it gets redistributed, someone makes some modifications and so forth, it will always remain under the GPL licensing, always attributing back to that GPL agreement, making it freely available to whoever wants to use or access that software. Okay, in this module, we covered a lot of important information, such as global privacy laws. We talked about current challenges. We talked about laws that can influence and affect information technology security, such as the Gramm-Leach-Bliley Act, HIPAA, HITECH Act, the Sarbanes-Oxley Act, GDPR, the CCPA. We also talked about the Brazilian version of the GDPR, or the LGDP. Also talked about licensing, EULAs, and equipment-specific and site licenses, and then also open source or the new General Public Licenses, or GPL. So I hope this module was informative for you. I'd like to thank you very much for watching. Hey everybody, welcome back to Pluralsight. I'm your instructor, Christopher Reese, and in this module we'll be covering intellectual property and import and export laws. So it may sound at the surface that it's not the most riveting material, but trust me, it's very important stuff here, and I encourage you to dig in and familiarize yourself with this content, which could have some pretty big ramifications if you don't do things properly, or if you're not aware of some of the nuances and the ramifications of not complying. So let's go ahead and look at what we'll cover in this module. We'll be talking about intellectual property, the definition and its purpose. We'll talk about the protections for intellectual property, such as copyright, trademark, patents, and also patent infringement. And then we'll dig into import and export laws, and some things around the Uniform Computer Information Transactions Act, cryptography controls and encryption. We'll also talk about high-performance computing restrictions and how that's changed over the last 5 to 10 years, and then also liability, both direct and vicarious, and we'll look at a small sample scenario of how our good friends at Wirebrain Coffee could get in some trouble if they don't do things properly. So let's go ahead and get started. All right, well, a good place to start here would be to actually define what is intellectual property. Intellectual property is a work or an invention that is a result of creativity, such as a manuscript or a design, to which one has rights and for which one may apply for a patent, a copyright, trademark, etc. So the question is, how does this apply to us, and what do we need to be aware of so that we're in compliance with the various laws and so forth? Intellectual property law is aimed at safeguarding a person's ideas, right? So at the end of the day, it is an idea, someone thought of something, and we want laws, or we need laws to protect the owner or the author, right? The creator of that thing, so that someone doesn't turn around and just rip them off, copy it, sell it, pass it off as their own, and so forth. So these ideas and creative works that exist in a tangible form, meaning it's something you can go out and actually touch. Movies, music, books, art, could be physical, could be electronic, and so forth, right? All of these things are tangible assets that are protected under intellectual property law. So let's take a look at 3 types of intellectual property protection. So the first is a copyright. So you may have seen that little circle with the C in the middle. That's a copyright symbol. And that protects original works of authorship fixed in a tangible medium of expression. In other words, something, book, movie, play, what have you. So the copyright covers both published and also unpublished works, right? So keep that in mind. It doesn't necessarily have to be published for it to be copyright protected. Next is a trademark. Again, a circle with a TM in the middle. You may have seen that symbol before, or you may not have the circle. You may just have a TM following some name. So a trademark protects words, phrases, symbols, or designs that identify the source of goods or services. And we'll talk about a differentiation between trademarks and service marks in just a moment. But for now, goods or services of one party and distinguishing them from others, right? So basically it protects your brand. Like you might have a hard time if you came up with a watch that looked just like a Rolex, but decided to call it a Rolex, as an example, right? So that trademark, the look, the feel, the design, and so forth, distinguishes it from something else. And then next is a patent. Patent pending is what you'll typically see before a patent is issued, but a patent protects an idea or a discovery. So ideas and discoveries aren't protected by copyright law, although the way they're expressed might be. But the actual patent itself is under patent protection. And we'll talk about the different types of patents here in just a moment as well.
What about the R circle, R symbol? What is that?
So first off, we have a copyright. So Title 17 of the United States Code established copyright law in 1976. So it's been around for quite a while. And it provides the copyright holder certain exclusive rights. And they are the right to reproduce that work, right? If you're the owner of that copyright, well, then you have the right to reproduce that work. You can copy it, you can reproduce it, you can do anything you want with it, basically, to make other copies or other representations available. Also, you can create what's called derivative works. So a derivative work would be something where you take the original and you change it somehow, you manipulate it in some fashion, and you make a subsequently, quote unquote, new thing. So it's a derivation or a derivative of the original. Also, you can distribute copies, as I mentioned, right? Reproduce works, you can distribute copies. You can perform that work publicly, and you can also display that work publicly, right? So all of these things are granted to you as a copyright holder. Now, from a business perspective, when we're talking about implementing copyright policy, it's important that we understand a few things, right? So we're not held liable from someone claiming copyright infringement. So as a company, are users aware of our current copyright policy and current copyright law, right? So if not, we need to make sure that there's training available, that we have that information out and disseminated to our employees so that they can't claim ignorance. One way to do that is to have training and then have the employees attest to that training. Maybe take a short quiz or somehow or other sign off that they received that training. Next, is software installed properly within each department? And this may come down to doing an audit, either programmatically or manually, to understand and make sure that software is installed only where it needs to be. People are not making illegal copies. They're not installing it once or buying it once rather, and then installing it in 50 or 100 different places. So it's important that those things are periodically audited before the actual owner of that software decides to come in and audit your environment. Because if and when that were to happen, that would be qualified as a bad day, especially if you have hundreds of copies of software illegally within your environment. Next are warranties and registrations filled out properly. You know, the warranty cards that you get when you buy something at home that you never actually fill out and you just rip up and throw away immediately? Well, those things need to be done in a corporate level. In a business environment, we should have the warranties and our registrations filled out properly. Now, typically, depending upon the size of the company, you may have a separate department that actually handles most of those things. But if the company is small enough, you need to make sure that someone, if not you, is actually taking care of this and on top of it. Because if and when something goes wrong, you need support, it comes time to renew, and so forth. All of those things have to be in place. And it also ensures that each copy of your software or each copy of your thing, whatever that thing is registered and owned, and it's actually documented that you have X number of copies within your environment. And then next, documentation reviewed prior to installing. This one is not as critical to do over and over again. If you do it once, it's pretty much rinse and repeat for X number of copies within your environment. But it is important to understand that you know, what am I allowed to install, where, how many copies, is it site specific, Is it throughout my entire enterprise? And so forth, right? So important to review that stuff before installing your software or putting that thing into production. And just as an aside, copyright protection generally lasts, at least in the US, for 70 years after the death of the author, right? So it's going to be around for a while. If that piece of software came out within the last 5 or 10 years, understand that that copyright is going to hold throughout the entirety of more than likely our working career, unless you're going to work to be 120. And if so, hey, more power to you. Okay, next, let's talk about an exception to the copyright law or copyright infringement, and that is the concept of fair use. So the fair use doctrine, which really isn't specifically called out or spelled out in copyright law, but is often used as an exception to copyright infringement, is primarily comprised of 4 main defenses. The first being the purpose and character of the use. So was the material taken transformative of the original work? In other words, did you take someone else's work and actually transform it, add to it, make it better in some fashion, transform it in some fashion, and then make it available to the public? That transformative nature can be an affirmative defense if it is in fact for the greater good. Parodies, as an example, are typically considered fair use because they're quite often a critical review of the original work, and a reasonable person would not assume that that parody is the original work. They realize it's usually outrageous enough to be understood as a parody and not the original work. Also, the nature of the copyrighted work. So factual works, such as biographies and so forth, and published works are more likely to be considered fair use than something that is fictional, or basically completely out of the author's mind. Things that are factual don't take as much time and effort and creativity to actually create, so the fair use doctrine could be applied here. The next is the amount and the substantiality of the portion taken. So the lesser amount copied from an original work, the more likely it is to be considered fair use. So in other words, if you take just a snippet, say 15, 20 seconds out of an hour or 2-hour movie, as an example, that's very likely to be found within fair use, within the fair use doctrine. If you copy 89 minutes of a 90-minute film, well, then more than likely, no, that will be found to be in violation of copyright, more than likely. And then next, the effect and the use upon the potential market. So does the use of that copyrighted material deprive the copyright owner of existing, new, or potential market? The copyright owner doesn't actually have to show that money was taken out of their pocket, so to speak, as long as the potential for that money to be taken out of their pocket exists. All right, so that's an important distinction to make. You don't necessarily have to show that you were harmed as long as the potential for harm was there. So the effect of that use can have significant impact on the outcome. And the thing within the fair use doctrine is that it's a case-by-case basis. There is no clear-cut definition, or for the most part precedent, on what is and what is not fair use. It's typically decided case-by-case by the judge. So it's very unpredictable how these things turn out, and taking something all the way through to trial in a copyright case can be extremely expensive, hundreds of thousands of dollars up to millions of dollars. So the key takeaway is be very careful when you're using someone else's work. Either 1, get their permission, or 2, try to stick within the fair use doctrine guidelines here as much as possible. And then something else to keep in mind, does acknowledging the work protect against the claim of infringement? So you might think yes, you might think no. Well, what is the answer? The answer is no, it does not. In fact, it can actually have the opposite effect. As an example, violation of the right of publicity. So the person, the owner of that copyright, may or may not want to have that work publicly available. Again, the key takeaway, don't assume that simply referencing the original work will get you around any type of copyright infringement. Okay, up next, let's talk about a trademark. A trademark is a word, a phrase, a symbol, or a design that identifies and distinguishes the source of the goods of one party from those of others. And then we have a service mark. A service mark is very similar in that it's a word, a phrase, a symbol, and or a design that also identifies and distinguishes the source of a service rather than goods. So very similar. Trademark is for goods. A service mark, as the name implies, is for services. Now, when we talk about trademark infringement, at least in the U.S., the U.S. Patent and Trademark Office, the U.S. TPO, states that trademark infringement is the unauthorized use of a trademark or a service mark on or in connection with goods or services in a manner that's likely to cause confusion, deception, or mistake about the source of goods and or services. And keep in mind, this is typically handled as a civil matter, right? A lawsuit that's going to be normally handled in federal court. It could be handled in state court, but it normally ends up in federal court. So basically what we're protecting against with trademark infringement, hey, you have a brand, you have a good, a service. If someone were to come by and do a knockoff and make it close enough that it causes confusion, remember I talked about the example between Rolex and Rolex, right? If it's close enough that it causes confusion in the buyer's mind, well, then there's a trademark infringement there, or at least the grounds for a trademark infringement suit. It would go to court, and then of course it's up to the judge and the court system to figure out who's at fault, whether there actually is infringement or not. Next, we have a patent, and a patent is a grant of protection for an invention. This gives the owner of the patent the right to stop someone else from making, using, or selling that invention for a term of between 14 and 20 years. All right, so you're asking, okay, why the difference? What makes one worth 14 and one versus 20? How do we know what's what? Well, I'm glad you asked that. We have different types of patents, each assigned with a different term. So there's 3 main types of patents. We have a utility patent, and a utility patent is basically inventing a new process, some method of manufacture, or a composition of matter, or an improvement to an existing idea. And a utility patent has a 20-year term associated with it. Next, we have a design patent. Now, a design patent is a new or original design that ornaments a manufactured device. So we're not creating something new. We're not manufacturing a new thing. We're basically improving upon that in an ornamental way, right? It must be ornamental, not functional. So that ornamental patent or the design patent is good for a 14-year term. And then we have something referred to as a plant patent. Plant, as you might guess, is for actual plants, right? It's a novel, non-obvious, asexually reproducible plant. So it sounds a little more glorious than it is, but it's also referred to as breeder's rights. So if you're a horticulturist or someone that's very adept with mixing plants together to create a new breed of plant, well, then you could apply for a plant patent. Out of the three, that's the least applied for patent, but they do exist and it is possible to get one. And as with the other two, there's a finite term. Here we're talking a 20-year term associated with that patent. Okay, let's talk about document management and retention. So as we know, companies must keep records of various types for defined periods of time based upon the type and geographic location and so forth. So things like business records, financial records, personnel records, taxes, HR records, and so forth. So it kind of goes without saying, but just to reiterate, an organization must not destroy documents simply because they provide unfavorable evidence, right? So if your company is the subject of an investigation, it's not prudent, it's not wise to turn around and start shredding documents. We can think of companies that have done that in the past, like Enron being a good example. We've talked about them previously. Doing that is destruction of evidence. It's obstruction of justice. So in other words, a no-no. Some document retention guidelines, and these are just a few that kind of deal with patents, trademarks, copyrights, and so forth. There's an entire slew of different objectives and guidelines for different types of documentation, right? So this is not an exhaustive list by any means. So with regards to document retention in the United States, basic commercial contracts, we're looking at 4 years after discharge or completion. For product liability, we're looking at permanent, meaning it needs to be stored for the life of the company. Patent deeds, 25 years. Trademarks, life of the trademark plus 25 years. For copyright, 120 years after the author's death. And then contracts and agreements, again, permanent. For Australia and New Zealand, it's similar, not exactly the same as the US, but pretty close. So for basic commercial contracts, we have 6 years after discharge or completion. For product liability, there's a distinction here. Instead of it being permanent, like it is in the US, there's a minimum of 7 years. For patent deeds, 20 years. Trademarks, life of the trademark plus 6 years. And then copyright, 75 years after the author's death. Contracts and agreements, a minimum of 6 years. And if we take a look at the UK, again, similar, 4 years after discharge or completion for basic commercial contracts. Product liability is a minimum of 10 years. Patent deeds, 20 years. Trademarks, life of the trademark plus 6 years. And then copyright, 50 years after the author's death. So the takeaway for that one, if you want copyright protection for your family and so forth down the road after you die, perhaps you might want to think of doing that in the US, right? 120 years after the author's death. But for contracts and agreements, a minimum of 7 years. So again, this is just a very small smattering of different types of document retention guidelines. This obviously goes into much more depth. This is just covering the surface, but it gives you an introduction and an overview to the fact that it's going to vary depending upon the type of actual document, right? Trademarks, copyrights, and so forth. And then also where you're located globally. Okay, so let's talk about import and export laws. So the laws will vary, obviously, depending upon jurisdiction. In the US, laws have been crafted to control interstate and also international commerce, and such things as controlling cryptographic functions for e-commerce and also encrypted communications as an example. So there's something referred to as the Uniform Computer Information Transaction Act, or UCITA, and it was an attempt to modernize computer laws for the software era. So it added restrictions to make software makers liable for defects and errors in their programs. So it basically did away with the end user license agreement. This was really only passed by 2 states, Maryland and Virginia, and it was actually aggressively opposed by most states. So it's really not in effect. But I did want to present it here because it's good information to have and know that there are attempts in different forms and fashions to make software, to make programming, to make things in the quote-unquote digital era conform to traditional type laws and vice versa. Not uniformly successful, pardon the pun, as in this example from the Uniform Computer Information Transactions Act, really only taking place in 2 states currently. Something else that places restrictions on commerce, specifically around high-performance computing, what this amounts to is there are some restrictions on companies in the United States who want to export high-performance computing systems, or HPC systems, to other countries. So why is that an issue? Well, traditionally speaking, those types of high-performance computing apparatuses, whether it's a single computer, a supercomputer, if you will, or networked computers clustered together to give high-performance computing standards, the thought was, or the fear is, that those types of computer systems can be used to do war simulations, nuclear bomb testing simulations, and so forth, and help advance those programs in areas of the world where that may not necessarily be the best thing. So what it amounted to is Tier 3 countries and Tier 4 countries. We'll talk about both. For Tier 3 countries, there was laws passed that excluded them from receiving computer systems that would allow them to operate above 190,000 MTOPS, or millions of theoretical operations per second. So they couldn't get these types of systems without a special license. It had to be issued by the US Department of Commerce. Tier 4 countries, no computers were allowed through direct or indirect trade. So if you were a country on the Tier 4 list, no go. If you were on the Tier 4 country list, then as a US company, you could not sell directly or indirectly to those countries. So let's take a look at the HPC export control tiers with a little more detail. So Tier 1 countries, Western Europe, Japan, Canada, Mexico, Australia, New Zealand, the restrictions, nothing really in place here. No license required for exports or re-exports of computers to or among these countries, right? Exports of unlimited MTOPS are permitted. Record keeping was required, however, so record keeping by U.S. exporters of HPCs above 2,000 MTOPS required, which is basically almost any computer nowadays. So tier 2 countries, you can see here, you can read through the list. Licenses required for exports or re-exports of HPCs above 10,000 MTOPS. Record keeping is required again, and reporting by U.S. exporters of HPCs up to 10,000 MTOPS are required. For tier 3 countries, and you can read through the list here as well, some of which are like India, Pakistan, the Middle East, some states in the former Soviet Union, People's Republic of China, and so forth, those export licenses are required for exports or re-exports of HPCs above 2,000 MTOPS to military end users or to nuclear, chemical, biological, or missile end users or uses, and then licenses required for all HPCs above 7,000 MTOPS to all end users or uses. Record keeping, again, needs to be in place, it needs to be accurate, so record keeping and reporting is required for all HPCs between 2,000 and 7,000 MTOPS. For tier 4 countries, Cuba, Iran, Iraq, Libya, North Korea, Sudan, and Syria, no computers are allowed through direct or indirect trade, right? And record keeping is obviously not applicable because there is no sales or trade allowed. So what we just talked about was export control, tier restrictions based on country, and so forth. There's a lot of talk about doing away with that system because it's just not necessarily valid anymore. And the thought being it has the opposite of the desired effect. With the thought being that if the US companies don't produce that equipment, some other country will produce that technology and sell to these countries. So the US and the companies that the US associate with would end up losing business. And at the end of the day, it really has no difference as far as who can access what types of systems. So a more recent advancement is something referred to as the Wassenaar Arrangement, right? That deals with conventional arms and dual use export control. So Wassenaar being a town outside of Hague. And there are actually 5 divisions or 5 areas where export control comes into play. So the Wassenaar Arrangement is for conventional arms and dual use. Then we also have the Missile Technology Control Regime that deals with missiles, obviously. We have the NSG, the Nuclear Suppliers Group. We have the Zander Committee, which is again for nuclear. And then also the AG Group, the Australia Group. And that deals with chemical and biological type of systems, weapons, and so forth. The Wassenaar Arrangement dealt with conventional arms, dual use, basically high performance computers, and also traditional munitions. So, as I mentioned, the Wassenaar Arrangement, formally established in 1996, and there are 42 member countries. And what it is comprised of is a voluntary agreement for export control. So it's a voluntary export control regime whose member countries agree to control exchange of conventional weapons and also dual-use goods and technologies. And when I say dual-use goods, I mean things that have both military and also civilian use. So as an example, the Wassenaar Arrangement. Say I am a shipping entity and I want to do business with whoever. I have dual-use goods, whether it be laptops, servers, software, what have you. Well, if I want to sell these types of things based upon the Wassenaar Arrangement, I would then need an export license. I would have to apply for that license. And the factors that go into whether I get that license or not are things like the policies of the destination country, right? Who am I shipping to? And what is their actual policies on how they're going to use those goods, how they maintain documentation, record keeping, and so forth. What is the security situation in the region? Is it volatile? Is it today a friendly country that could very quickly become an unfriendly country? Well, then that license may be denied. Also, credentials of the end user. Who's actually being sold to? What do they do? Are they on some type of blacklist? Are they on some type of no sale list, and so forth? And then what's also the specified end use? How are they going to actually use that piece of equipment? Software, hardware, and so forth. So if all of those things are on the up and up, and they're in agreement within the policies of the Wassenaar Arrangement, then the license is issued, and that shipping entity can then ship that piece of infrastructure or software to the end user. So to give you an idea of what things are covered under the Wassenaar Arrangement, for munitions list, there are 22 categories of equipment, software, and technology specifically designed for military use. Dual-use goods on this list contain over 1,000 items that have civil application, but can also be used to either enhance or augment military capabilities. Okay, next, let's talk about liability. So liability is the state of being responsible for something, especially by law. So as this applies to business, the question is, can a company be held liable for the actions of its employees? And the answer is yes, under certain conditions. So when it comes to liability, there are 2 main categories of liability that companies face: direct liability and then vicarious liability. So direct liability occurs when a company permits an employee's actions. So this is typically when an employee is acting on behalf of the company. Company officers acting as a surrogate, as an example. The other is vicarious liability. So this is liability assigned to an employer or other principal for his agents or employees' act performed in the course of their employment or other duty. So the concept of vicarious liability is rooted in the fact that the superior party, the boss as an example, or the employer, has induced, facilitated, or otherwise contributed to that agent's acts. So as an example, let's say we have Joe, and Joe has been instructed by his company to get into his car, to drive across town, into the city, and do some work at one of their client sites. So it's part of his normal duty. He's using his car to get from point A to point B. Well, in the course of those duties, he gets into an accident. There's damages to the car, there's damages to another person because he got into an accident with another person in another car, so there's damages to both, and the person in the other car is injured as well. So, is the company liable in this situation? And the answer is yes, the company can be held vicariously liable since the employee incurred the accident in the course of their normal duties. Now, I'm not a lawyer. This is not a strict legal interpretation, so I'm sure it varies case by case. but generally speaking, yes, vicarious liability would apply here. Conversely, let's look at Joe again in his car, getting ready to do the same task. Right? He's going to go into the city and do some work at a client site. But instead of driving to the city, he decides to go the exact opposite direction to someone else's location in an unauthorized stop. And guess what? Along that way, he gets into an accident and injures another party. Very similar type of accident. Gets in a fender bender with another car. The other person is injured. Is the company liable at that point? And the answer would be probably not. The company would not be vicariously liable because the employee decided to forego his duties and make an unauthorized stop, and in this case, completely in the opposite direction of where they should be going. So again, not a strict legal interpretation. So this is case by case, take it with a grain of salt. But generally speaking, in this case, even though he's doing the same type of thing during his normal work hours, he's driving to the city like he's supposed to, he's doing it in an unauthorized fashion, going in a direction he shouldn't even be going, and gets into an accident. So there it could be argued that the company is not held vicariously liable in that instance. Another term I want you to be familiar with is the term of contributory negligence. And this is negligence on the part of an injured plaintiff, which, combined with the negligence of the defendant, caused the injury or the damages. So in other words, yes, the plaintiff was injured. That's not argued. He, in fact, was injured because, in part, the company did something wrong. They did something not in accordance with just generally perceived safety standards, but the plaintiff should have known better. They did things in an unsafe manner. They contributed to that negligence, right? They contributed to their injury. So yes, there could be an award in the plaintiff's favor, but instead of having 100% award go to the plaintiff, there may be a reduction, maybe a half or a third, depending on how many parties are involved, because the plaintiff was actually involved or contributed to their own injury. Okay, so here's an example liability scenario. We're looking at the newly hired senior HR director. And in this example, we have Wired Brain Coffee hired a senior HR director to oversee HR and related IT functions for all employees. Well, as luck would have it, that senior director and executive management had a bit of a falling out. There was some animosity between the two, and the senior director decided to leak information on 3,000 customers, put it out onto the internet, they uploaded it to Pastebin. All of a sudden, that information is now available for whoever wants to see it. Through the process of investigation, it's found out that the senior HR person did this, so that senior HR director is arrested and held directly liable, and the company is also found vicariously liable. And why is that? Well, it was found out through the course of the investigation that the company did not take adequate precautions and safeguards to protect that data. It was found that they left things out in the open, they didn't encrypt, they didn't have policies in place to prevent that information from being removed from the offices and so forth, right? So it was a host of things that they could have done, that they should have done, that they did not do. So as you might guess, damages are awarded to customers as a result of that public information being leaked out onto the internet. So yes, companies can be held liable for the actions of their employees, even if they didn't direct that employee to do something specific, right? The employee took the action upon themselves. But if the company did not take adequate precautions to prevent that thing from happening, whatever that quote-unquote thing is, then yes, they could be held liable in certain instances. Okay, in this module, we covered a lot of really good information. We talked about intellectual property, definition and purpose. We talked about protections, including copyright, trademark, patents and patent infringement. Also talked about import and export laws, such as the Uniform Computer Information Transactions Act, particularly how it applies to cryptography, controls, and encryption, also high-performance computing restrictions. Then we talked about liability, such as direct and vicarious, and then covered a sample liability scenario. So I hope this module was informative for you. I'd like to thank you very much for watching. Hey everybody, welcome back to Pluralsight. I'm your instructor, Christopher Reese, and in this course, we'll be covering ethical considerations in IT security. So let's go ahead and take a look at what we'll cover in this course. We'll be talking about privacy and some of the ethical considerations around that balancing act between privacy and security. We'll talk about notifying employees, social media monitoring, if and when it's appropriate, and so forth. And then we'll talk about the technical aspects of monitoring employees. We'll talk about the methods and the tools, things like court orders and subpoenas, when things get a little more real, right? We have to go out and actually do some deep down investigative work. We'll talk about log files, intrusion detection systems, and some of the tools that are not necessarily designed to monitor the employee per se, but do monitor the employee as we're looking for breaches, external activity, and so forth. So not everything is geared directly at the employee, although they may be involved in that monitoring. And then we'll talk about example monitoring scenarios, and again, some of the ethical considerations around that. So let's go ahead and get started. So when we talk about privacy, it really boils down to what defines privacy. And that even is a touchy subject because it really depends upon who you talk to. It could be the right to be left alone. It could be the right to be anonymous. And as I'm sure you know, they're not the same thing, nor are they mutually exclusive. They can be achieved in tandem. And then we'll talk about modern tort law, right? The 4 pillars. And that is intrusion of solitude. And that basically means an intrusion upon seclusion, right? Someone's right to privacy, right? To be left alone. So intrusion upon seclusion, quote unquote, occurs when a perpetrator intentionally intrudes, physically, electronically, or otherwise, upon a space, right? A private space, solitude, or seclusion of a person, or the private affairs or concerns of a person. So in other words, hacking into someone else's computer would be an example of an intrusion upon privacy. Next, public disclosure of private facts. That one goes without saying. Also, false light, bringing up a situation, facts, and so forth that are just not correct, right? They're putting them in a false light, making them look like they've done something that they haven't, or said something that they haven't, and so forth. So terms that immediately come to mind, like clickbait and the tabloid fodder, those types of things that are just these fantastical stories that really aren't true, that's putting someone in a false light. And then appropriation would refer to the fact that you're taking someone else's identity without their permission and for your direct benefit. So in the US, there are a number of privacy laws that I want you to be aware of. You don't have to necessarily have a deep understanding of these, but just be aware that they exist. And then if you want to dig in deeper, obviously you can. So the Electronic Communications and Privacy Act of 2000, basically designed to regulate the interception of electronic indications such as email. Then we have the Privacy Act of 1974. This imposed limits on the amount of personal information that can be collected by federal agencies. Next, the Fair Credit Reporting Act, amended in October 13 of 2006. This regulates the collection and use of personal data by, as you might guess, credit reporting agencies. And then the Federal Right to Privacy Act. This is from 1978, and this limits the amount of information from customer files that financial institutions may disclose to the U.S. federal government. Next, we have the Video Privacy Protection Act of 1988, and this prohibits movie rental companies from disclosing customer names and addresses or the subject matter of their purchases for marketing use. So I know there's probably a lot of happy people that actually was a law enacted back in the day. Next, we have the Cable Communications Act of 1984, and that prohibits cable television companies from using their systems to collect personal data concerning their subscribers without the subscribers' express consent. And then we have the Equal Credit Opportunity Act, and that prohibits creditors from collecting data from applicants, including gender, race, religion, birth control practices, national origin, and similar information. And then last, the Family Educational Rights and Privacy Act from 1974. So that allows students to examine and challenge their educational transcripts and other records. Now, when it comes to privacy laws in the UK, there's some other ones I want you to be aware of as well. So historically, we have such things as the Data Protection Act of 1984, and then an amendment to the Data Protection Act in 1987, and then the EU Data Protection Directive in 1995. So you can see there's a couple iterations of this as we go through. And then the Data Protection Act was again updated in 1998. So that's historically speaking. Currently, those things have kind of morphed into the GDPR, which you've covered previously, and then also the Data Protection Act of 2018, which amended or updated some sections of the GDPR. So there are a number of protection rules, in some cases or in many cases, more restrictive than in the US and more geared towards protecting individual citizens' privacy. So just some things to keep in mind. Again, if you want to dig into any of these more, I encourage you to do so. It's worthwhile to get as much information about this stuff as possible, just so you understand some of the ethical implications of what some of these rules address and how your company's policies or actions may or may not interact or potentially conflict with some of the directives in these laws. So one of the key elements to some of the UK data privacy laws, GDPR specifically, is the right to be forgotten. So what does that actually mean? Well, the right to be forgotten is the right to be removed from search engine results that are inadequate, irrelevant, or perhaps no longer relevant, or even excessive in relation to the purposes for which they were processed. So things that are no longer accurate, or if it's no longer pertinent to you, or perhaps over the top and provides more information than is really necessary, stuff that you don't necessarily want out there, you have a right to have that information removed from search engines and search engine results. So let's talk about some company obligations to protect security. Again, getting back to whether it's the US laws, UK laws, or elsewhere in the world, a lot of countries are now adopting similar regulations. Physical security goes without saying. We need to make sure that we're providing adequate protections against physical break-ins, people crossing into the barriers of our workplaces, obviously doing physical harm, but then also breaking into our data centers and accessing data inappropriately or without authorization. Then computer and network security, making sure we're putting things in place so that our computers, our networks are secure. We have policies in place like password complexity issues, two-factor authentication if possible, different types of encryption, encryption at rest or in transit, and so forth. And then also network infrastructure security to make sure that our routers, switches, and the perimeter devices that may be accessible from the outside, anything that's public facing or internally facing, assuming someone were to breach our perimeter and actually get physical access to the building, is our network infrastructure secure? Do we have such things in place so they can't just plug into a network jack and gain immediate access to our network? And then proper training of employees. This is an ongoing thing. Obviously, it's not a one and done. We must periodically make sure that our employees are all on the same page. They all understand that security is everyone's job. They also understand what's expected of them, what's an acceptable use, and what's, of course, unacceptable. And then also understand to the extent that they're potentially monitored so that they have a proper expectation, or perhaps, depending upon the location, no expectation of privacy. If they're using corporate resources, laptops, phones, and so forth, well, then they should be properly trained to understand that anything on those devices could potentially be accessed by the company at any time. So that lack of expectation of privacy will go a long way to making sure that they're using those corporate resources for corporate purposes. Okay, so let's talk about potential damages from mishandled data. So if we don't have things properly set up and we don't have the systems in place and so forth to make sure that we're protecting our data, what can possibly go wrong? So first off, we could have loss of intellectual property. So proprietary information, data, or programs could be stolen, used by competitors, or in one form or fashion, bring damage to the company. Intellectual property, as we know, can be a key differentiator, can be a competitive advantage. So if that goes away, if that goes out the door, then that potential competitive advantage and so forth may go out the door with it. So it's very important that the company does, in fact, safeguard this data. Next, we could have loss of revenue, financial loss due to disruption of business, loss of, as I mentioned, the competitive advantage and so forth. These things can happen very, very quickly up into the point where it could actually force the company out of business, depending upon how great the loss is. Next, loss of brand and reputation. So that could be loss of consumer confidence, investor confidence, employee trust, and so forth. And as we know, it takes a long time to develop trust, to develop a brand, and develop a company, a persona that people actually want to do business with and interact with. It takes a long time to build that. It takes a very short amount of time to lose it if things aren't secured properly, if there's a customer breach and sensitive information is leaked out to the public, or proprietary information is gone, and now competitors can potentially do what you do, maybe even better. So those things have to be secured as much as possible. And this becomes more and more difficult as we talk about transborder data flow, because we have a number of things to take into consideration. So where are the parties located? They don't necessarily all have to be in the same location, the same part of the world even. So who has primary jurisdiction? So when we do have a case where we are trying to investigate something, or we need to actually report something, who do you report it to? Who has primary jurisdiction? Is it where the victim lives? Is it where the perpetrator lives? Is it actually where the servers reside, and so forth? Right? So does the offense cross state, national, or international borders? And can the offender be extradited, and or is there reciprocation? So all of these things can complicate matters of property theft, intellectual data theft, and so forth. Because hackers, as we know, can come from any part of the world, and they can take data across state lines, country lines, etc. very, very easily. So as an example, we may have somebody located, let's say, where the first pin is on the map here. Well, the actual attacker may live on the other side of the globe. And the actual servers that they're interacting with, our servers, might be located in a different part of the world. So it's very easy to get caught up in a bit of a quagmire as to who has jurisdiction, how do we prosecute, how do we investigate, and so forth. So these are things to keep in mind when we're talking about where's our data live? Do we keep things within our own country? Do we allow it to be spread across other countries for fault tolerance, disaster recovery, and so forth? So all of these questions are a bit out of scope as far as what we can dig down into here, but just something to keep in the back of your mind. Where the data lives can in fact have an impact on how quickly you can recover from a breach if one in fact occurs. Now, when it comes to monitoring employees, there are some ethical considerations we need to think about, right? Do we monitor everything or just business related? So in other words, if your employees have a corporate laptop, a corporate cell phone, or a smartphone, do you monitor everything that takes place on there? Or do you just monitor business related activities? Because depending upon where you live, where your business resides, and so forth, you may have the option or the opportunity to do both. And if you do, to what extent do you actually notify employees? Once these decisions are in place, do you do it in a manual or an automated fashion? Is it triggered by a keyword or activity? So there's more or less no manual bias involved. If this action happens, it automatically starts triggering or automatically starts recording or monitoring. Or do you just monitor everything? And then also, has the company privacy policy been communicated to employees? So it's typically a best practice, if in fact you're going to monitor what employees do, that you let them know that. You give them some type of screen, a pop-up, that they're reminded of that periodically when they log onto the internet or they access the website or so forth. And then also within their training manual, the training materials, company policy documents, and so forth. Make sure that's been communicated very, very clearly to the employees, and they've actually signed off or attested to the fact that they've reviewed this information, it's clear to them, and they agree. That way, there's no legal gray area down the road where they can come back and try to nullify that monitoring that's been taking place. Some use cases for monitoring, right? We have a boost in productivity. Some companies report that when they actually alert employees and let them know that they're being monitored, or at least have the potential to be monitored, such activities as, tracking time spent on social media or web surfing or other quote-unquote non-work related activities. When employees know that those things are potentially being monitored, they spend less time doing those things. And in turn, they're more productive, right? That's the thought anyway. So 9 times out of 10, I can see where that is in fact the case. It can also deter or detect criminal activity. So it can detect intrusions or breaches, criminal activities such as threats and harassment, illegal behavior, visiting illegal websites, or being involved in illegal transactions, and so forth. Monitoring can also take the form of tracking employee locations. So if you have remote workers, either ones that travel from site to site or actually do work out in the field, tracking employee locations can help with adhering to company policies, making sure workers don't speed, making sure workers are where they're supposed to be, when they're supposed to be there, right when they clock in and clock out. And as I mentioned around speed, making sure that they're traveling safely. And there's monitoring software that's available via GPS, via smartphone apps that can track and then make alerts when an employee leaves out of a geo-fenced area. So if they're outside of the work area, you could become alerted. Or if they're driving too fast, you could become alerted. And you can also send push notifications to the vehicle and say, hey, slow down, we're watching you. Those things, when they're in place, and assuming they're communicated properly, have a positive effect on employee productivity, safety, and so forth. The issue comes into play when these things are in place, kind of stealthy, right? So repetitiously, and the employee doesn't know they're being monitored, and then all of a sudden it comes to light, and it makes it look like the company's doing something sneaky. So again, I'm not saying one way is better than the other, and I'm certainly not advocating. Every company is different. Of course, it's up to you and your own corporate policies. But generally speaking, communicating is usually your best option. That way the employee understands fully what's going on. And then lastly, protecting IP or intellectual property. So ensuring proprietary company, employee, and or customer data is secure and not being removed from the company, whether it's exfiltrated digitally over network communication, network traffic. It could be copied over to a USB or removable drive, or a CD-ROM if you want to go back in the Stone Age, or a zip drive even for people that remember those things. So there are many ways, obviously, to take data out of a company, and there are safeguards we can put in play, whether it be removing access to removable drives, making sure we monitor network traffic, especially traffic that's exfiltrates or leaves the company perimeter, can help us reduce the chances that data will leave the company in an unauthorized fashion. Okay, so when we talk about the things that are typically monitored, let's talk about from the company's perspective. Let's just kind of follow this through. So we have an employee that we're going to monitor. That employee, either we make them aware that we're monitoring certain things or we don't. Let's assume that in this case we do. So in other words, this company wants to be transparent and allow the users to basically know what is expected of them and where they're being monitored. So they have an acceptable use policy. There's also pop-ups when they log on to their PC and so forth. So when he logs on to his desktop, he'll see a message that says, hey, transactions here may be monitored. Same thing with his laptop. Same thing with email communications. They all can be monitored. Regardless of whether they're personal or business related, if they're done on a business or a work device, laptop, smartphone, and so forth, those communications could in fact be monitored, and he's aware of that. And then also any logs, any activity, when he browses through the network, accesses file shares, applications, and so forth, all of those things are monitored and logged somewhere. So activity throughout the course of a business day can be logged, tracked, can go back in time and see what was done and so forth. So as long as the employee is aware of all these things, then he's going to know, hey, I shouldn't do things that I really shouldn't be doing on work equipment. It's going to boost productivity, but it's also going to give him a sense of trust and transparency because he understands where the boundaries are, what the parameters are. Keep in mind, a company could do all of these things without alerting the user. That's a business decision that's applicable to your organization and your company specifically. It's not something that I can advocate or say the right or wrong answer here. So it will vary depending upon your unique situation. So at the end of the day, we really want to balance what's reasonable. So a defined privacy and acceptable use policy, as I mentioned, so that way everyone's on the same page. Everyone is aware of what's being monitored, what's not being monitored, what's in scope, out of scope, and so forth. Also, we now have a level set where we set expectations for the employee's expectation of privacy, or in certain cases, the lack thereof. So as long as everyone's on the same page, we should be good to go. Now, the area that has the potential to get a little gray-ish is BYO devices, right? Bring your own device policies. So if an employee is allowed to bring in his own laptop or his own smartphone, iPad, what have you, there are tools that allow you to section off a piece of that device for corporate use and make it controllable by the corporation. Or you may say, if you bring your own device, you're going to attach it to our network, we're going to control the entire thing. So again, that's a company by company unique situation. It needs to be defined in your acceptable use policy and then acted upon accordingly. So do things in a transparent fashion. If you allow BYO devices, then either invest in something like Mobile Iron or good messaging so you have the ability to cordon off or section a piece of that phone for corporate use, or make it a blanket policy that is subject to corporate auditing and so forth without notice. Okay, so as far as monitoring goes, new tools are constantly being developed. We know that, the users should know that. So we can look at things like login, logout times, productivity. We can look at social media postings. Again, a lot of these things can be automated and done in a fashion so that anything triggers, if we're looking for specific keywords or specific types of activity, it can be automatically triggered, captured, and logged and alerted so that someone in your security operations center or whatever your monitoring facility is called can look at this, pretty much in real time and see what's going on. All right, so social media postings, email, full content, or keyword searches. Again, it depends upon the software and how you utilize it. Live stream users' desktops even. It's possible to, if in fact a user triggers or you just want to see what a user's doing, if it's within a corporate environment, you can bring up that user's desktop and see what they're looking at in real time. You can lock their screens so they can't do anything while they're there, so you kind of retain what's going on. And then you can send someone down to their office or to their cubicle to tap them on the shoulder and say, hey, come with me. We can also covertly install and uninstall agents. So again, getting back to the transparency thing, you can be totally transparent and allow people to understand what's going on, or it can be done kind of in the background or even covertly so they have no idea that they're being monitored to that degree. And then also we can display messages on users' desktops, whether it's a push notification that some activity needs to take place, or if they're doing something that runs afoul of the acceptable use policy, a message could be displayed and say, hey, whatever you're doing, stop doing that. As an example, here is a screenshot from an application suite called Terramind that allows very granular employee monitoring across a wide berth of activities. So you can look for rule-based, policy-based, live desktop streaming, social media, pretty much you name it, it can monitor down to a very granular level what each employee is doing, what time they log on, what time they log off, how productive they're being, and so forth. All right, as an example, again, here's one showing kind of moment by moment what each individual user is doing, what they're looking at, what actions they're taking, and then even bring up a live view of someone's screen and see what they're seeing on the screen. Obviously, not every company is going to need or want this level of granularity and this level of monitoring, but I'm just kind of giving you an example of what's possible. There are some extreme monitoring tools out there that allow you to get very, very granular data on what each employee is doing pretty much any moment of the day. Now, when it comes to monitoring social media, 26 states currently have passed laws barring employers from forcing employees to provide access to social media accounts. So it may or may not be lawful in your state to actually require someone to provide their credentials so that you could log into their social media and monitor what they're doing, right? So again, that's going to vary state by state, and the policies themselves, of course, will vary from company to company. 16 states have barred academic institutions from forcing students to provide access, refusing to admit them, or otherwise disciplining them for things they do on social media. Okay, so understand that social media is a big part of everyone's lives. Over half the states have passed laws barring employers from forcing employees to provide access, and then 16 states have barred academic institutions from doing the same, as well as not allowing them to refuse admittal to someone based upon social media postings and so forth, or otherwise disciplining that student. Okay, when it comes to employee protections, a couple things here. Fourth Amendment protects against unlawful search and seizure, and you might think, great, hey, the government's got my back, I'm protected, but that applies to public sector, government, law enforcement, and so forth. That does not apply to the private sector. So companies are free to monitor employees, as I mentioned, hence the Terramind application that I just showed you, and there are many others that do similar things, right? There are different levels, different tools, and so forth available, but all of these things are legal and are used by companies in various situations. So to that end, work-related or personal computer, email, communications while at work, if you're in a corporate environment, whether it's your own device or a corporate device, you have the ability to monitor your employees' actions. Now, there are some nuances that will vary state by state. I would recommend you check with your HR department to be specific, but understand that those things are possible, right? There's an ethical consideration, hence the name of this course, right? We want to balance everything, make sure we're not being overarching, but also protecting the business, making sure we're getting the most productivity out of the employees. Now, when it comes to court orders and subpoenas, privacy laws such as GDPR and CCPA protect employees from unreasonable data collection and usage. Doesn't cover surveillance, though, as a result of a lawfully obtained court order or a subpoena. So just putting it out there that these laws do in fact exist and they protect the average citizen from unlawful or unreasonable data surveillance, data gathering, and so forth. But it doesn't prevent a lawfully obtained court order or subpoena, right? Those things still apply. They will supersede GDPR, CCPA, or any other local regulation, right? If a crime's committed, all bets are off. So an employee doesn't have to be notified, nor do they have to be made aware that they're the target of data collection in this instance, right? So just to be clear where we draw the line for transparency. Very briefly, just to cover some attacker tools to set the stage, so to speak, right? We have bad guys come in all shapes and sizes, all flavors. They can be individual people, they can have religious or some type of social agenda, they could be state-sponsored, they could be organized crime, right? Various levels of sophistication. They will either create their own or buy attacker toolkits from the darknet, from other hacking organizations, and so forth. There are a number of tools available for penetration testing and all types of reconnaissance type tools that are freely available in different types of Linux distributions, freeware tools that you can download off the darknet, and so forth. So the toolkits are there, and they vary in levels of sophistication. So they can install backdoors into systems and then install keystroke loggers. They could be browser plugins and do kind of drive-bys when you visit a website. That plugin would download code, could be to a mobile phone as well. We also have email generators that do just tons and tons of spam, phishing attacks, trying to get people to click on links and then download malware to their systems, right? So phishing is a big deal and is the primary attack surface that most breaches start with. Some type of phishing email that a user clicks on, opens up that link, and all of a sudden malware is installed on their system, and then an attacker has an inroad into the system. They try to install some type of persistence. They'll get in, raise their credentials, pivot, kind of go out through the system, see if they can find the jewels or the treasure within the network, take that data, either install worms, ransomware, or just exfiltrate data, depending upon what their goal and their mission is. So some additional monitoring use cases. So we may want to monitor not just to monitor employees, but for some other reasons as well. So some monitoring is used to prevent breaches, to prevent exfiltration of data, as I just mentioned, right? All these different toolkits exist, and depending upon the attacker's motives, they may be trying to exfiltrate data, intellectual property, trade secrets, customer data, and so forth, right? So we want to safeguard that employee and that customer data, along with any IP or proprietary information. So intrusion detection systems or prevention systems, IDS and IPS systems are a good tool for that purpose. SSL decryptors, that we actually decrypt the encrypted communications from our employees. They'll go through an SSL decryptor before it goes out onto the internet. So within the confines of the corporate environment, we can decrypt that traffic and see if they're actually exfiltrating sensitive data, person identifiable information, and so forth. And then also data loss prevention systems. Similar to what I just mentioned, those things can check for certain things like PII or credit card numbers, PCI data, HIPAA information, all that kind of good stuff. So we can set up rules that it will examine the traffic coming in and out of the network. And if it flags something, it will set off alarms and triggers that we can then have investigators or security personnel dig into more deeply. Firewalls and next-gen firewalls kind of incorporate some of these tools or all of these tools into one device. So they kind of put all of these things together and allow us to get deep packet inspection, DLP, IDS, or IPS systems kind of bundled together. It just depends upon the actual product that we're using. Some are more sophisticated than others, obviously. But all of these things help us to monitor what's going on within our environment, within our network, and hopefully protect against breaches, data exfiltration, loss of all the things you mentioned, customer confidence, employee trust and confidence, and of course, investor confidence. Okay, so very quickly, just to touch on intrusion detection and prevention systems, just so we're clear of what these things are. So if we're out on the internet, right, we have something coming into our network. We have a shared segment that will be public facing, exposed on the outside of our perimeter, so to speak. It's going to sit in front of a firewall, and then behind the firewall would be our private network. Well, off that shared segment, we'd have an IDS system, this intrusion detection system, and it's basically looking at all the traffic that's coming from the internet to our firewall, trying to get into our network. If it flags traffic that it seems is suspicious, then it's going to send that event data to a database and then off to a network operations center employee who would then act upon that alert, or at least look through it to see what's actionable and what's not. Next, when we actually do find some wrongdoing or some reason to dig into an employee's activities a little more, I just want to touch on some very high-level evidence considerations. Again, we're talking about ethics within IT security management, just make sure that we're collecting evidence in the proper way and we're doing it in an ethical fashion. So if we have to actually go on scene for the first responder, quote unquote, do some type of investigation, make sure we photograph and document everything prior to touching everything. That way we know the state that it was in when we got there, how things were connected, and so forth. Collect and document physical papers, notebooks, as well as digital evidence. So we don't want to focus just on digital evidence, USB keys, CDs, and so forth. Also physical papers, notebooks, anything that might be pertinent to that case. And then also preserve evidence in a secure location with limited access, right? We want to make sure we have what's called chain of custody. Record a date and time location whenever that evidence is touched or if it changes hands. Again, we want to make sure that we maintain that chain of custody, that continuity of evidence. So if this case ever had to make its way to court for whatever reason, all of these things are covered, all the bases are covered. We're doing it in an ethical fashion. We're doing it according to best practices, and we can document that once we obtain that evidence, it never left our purview as far as chain of custody. It's always been maintained in a secure location. Every time it's changed hands, we have documentation of who did what and so forth. So that just helps build the case and also shows that you're doing things in the proper fashion. One thing I'd like to call your attention to is NIST Special Publication SP 800-86, and this is a much more detailed guide to integrating forensic techniques into incident response. So it's beyond the scope of this course. If you have more interest in finding a little more detail about the forensics process and how to do incident response in a proper fashion, then I would actually point you to this publication. There's also one for mobile device forensics. Great sources of information. I recommend you dig into those if that interests you.
Bro, if it was just dog, bro, dog.
Okay, in this module, we covered a lot of good information talking about privacy, talking about privacy policies, when to notify employees, random searches, the Fourth Amendment, what it covers and what it doesn't cover. We talked about social media and some of the ramifications of companies trying to perhaps force employees to give up their credentials, academic institutions as well, sort of how that kind of played out. Talked about monitoring of employees in a little more detail, some of the methods and the tools, and how granular that can get down to real-time streaming of an employee's data to some type of centralized monitoring software. Talked about court order and subpoenas. Remember I mentioned the Fourth Amendment and what it applies to. Log files and things along those lines. Also intrusion detection systems, a very high-level overview of what it does and where it fits into the grand scheme of things. And then an example monitoring scenario showing some screenshots from the Terramind application and what it can and can't do, how granular you can get when monitoring employees' actions. So I hope this module was informative for you. I'd like to thank you very much for watching.
Keep going, baby. We're just chugging on.
Hey everyone, welcome back to Pluralsight. I'm your instructor, Christopher Reese, and in this module, we'll be talking about security compliance management. So a great course, a lot of good information. Let's take a look at what we're going to cover in this course. We'll be talking about ensuring compliance and security operations, what that entails, some of the nuances associated with making sure we're compliant across the board throughout all areas within the organization. We'll talk about external factors as well as internal factors. We'll also talk about ways to define risk. We'll talk about compliance frameworks and enterprise security frameworks, such as NIST SP 800-53, how we can use that as an ESF, as well as ISO 27001 and 27002. And as I mentioned, using NIST as an enterprise security framework. It's one of several very good guidelines that can serve as a baseline. Not necessarily everything has to be taken in, as we'll talk about, but you can use some of it, pieces of it, or all of it, depending upon your organization and what fits within your company. And then we'll also cover an example scenario of how to apply one of these frameworks to a security decision. So let's go ahead and get started.
Okay.
Okay, so when talking about compliance, what is the compliance goal, or what should be our compliance goal? Well, we should ensure that ethical behavior across the entire enterprise is enabled, and that goes for people, process, and technology. In other words, everybody's doing their part, doing it the right way, doing the right thing, quote unquote, no matter what department they're in. And we have the same underlying guidelines throughout the organization, no matter where we're located globally. So when it comes to compliance, there are a few terms that I want you to be familiar with. We have policies. So policies are guidelines that help define appropriate behavior within an organization. In other words, what's acceptable and what's not. Next, we have standards. And standards are something that is set up by an authority as a rule to measure something, i.e. quantity, quality, the timing, cycle time reduction, how long it takes to do something, and so forth, right? We want a standard way of doing something. And then procedures. So they are defined and disciplined, repeatable set of actions to achieve a desired outcome, and they're utilizing standards to implement and enforce a policy. So when it comes to compliance management, a few things to keep in mind. Security policies, standards, and procedures are defined and executed. So when we ensure that compliance is being met, we need to make sure that such things as our security policies and our standards and procedures are not only defined, but they're also executed. Policies are reflective of compliance requirements externally imposed, potentially, through legislation, through regulation, and so forth, right? This depends upon what industry you're in and potentially where you're located globally. Policies are also reflective of internal compliance requirements. As an example, we may have the NIST framework, right? SP 800-53 or ISO 27001. This serves as a framework that our policies are built upon and gives us a standardized way of achieving our goals. Ultimately, all work together to influence people, process, and technology to ensure security operations function properly. So we're talking about compliance management with regard to security and security policies, but compliance management in general can apply or should apply to the entire organization. So not just security-related functions, but business functions, HR functions, everything within the environment should follow a standardized way of doing things. So when we talk about security from the business's perspective, there are certain things that we should keep in mind. All right, so cyber activities, security in this instance, have basically one of two main goals. We want to either contribute to revenue, and that's revenue generation, or protecting existing revenue, or manage costs, and that can be maintain, reduce, or avoid, right? Cost maintenance, cost reduction, or cost avoidance. So as we look at the various things that we do related to security within our business, we have to ask ourselves, is the action, is the tool, is the procedure, is the processes, whatever it is we're talking about, does that fit into one of these two categories? Does it contribute to revenue, or does it manage costs? And if it doesn't do one of those two things in some form or fashion, then we should ask ourselves, why are we doing that specific thing? Because as we know, it's easy to get caught up on the shiny object thing. Hey, look at that, a shiny object. Hey, a squirrel. Hey, this, whatever. And you can go off on a tangent very easily, especially when you talk about technology, because there's always a new thing. There's always a new technology, a new platform, a new tool, and so forth. Sometimes it pays to circle back, kind of refocus and say, okay, is the activity that I'm engaged in, is the process that I'm looking at contributing to revenue or managing costs? And that goes within compliance as well. If I'm doing an activity that is quote unquote to get me into compliance, does it do one of those two things? And if not, then we should look at another activity, perhaps something more appropriate that will reach that same goal that will fit into one of these two boxes. When we talk about risk posture and also risk exposure, a few things to be aware of as well. So risk posture, so we're on the same page, is a defined position on dealing with a potential negative impact and how to address that risk. So our risk posture is, okay, we know there's risks out there. Here are the different categories. Here are the different things we may come in contact with. What's our position on them? Do we avoid altogether? Do we transfer? And we'll talk about the different methods here in just a moment. But basically, what is our position on that specific topic? Next is the security posture. So that are the tools and the safeguards that are put in place to either reduce or mitigate risk.
Do I take what do I even do for the break, bro? It says 5-minute break. Okay, well, let's just start and then figure it out. Break. What's there to do for break? Alright, 5-minute break or something. A break, 5-minute break. Let's get the counter up here. 5-minute break. What do we do? Just check what's going on. I don't even know why. I don't even want to go out this, bro. I don't even know what to do. Good thing this 5 minutes goes by fast. Pro cannabis. Bro, no. Gabrielle Union? Who even is that? No one cares. Processed food stocks fall? That's awesome. Dang.
Ma ci vede curva, porco Dio.
Mire lo que ha pasado.
I'm sorry, but fucking God. You was on the phone, looking on the phone, driving up the stairs, and you completely got in our
¿Qué tal el jaguar?
line on the road.
La señora venía en el teléfono.
Porca Madonna.
Ella venía hablando por teléfono y mi hija.
Dang. That's crazy, bro.
Ella venía hablando por teléfono y mire lo que ha pasado ahora en este jaguar.
Why do you use
Afortunadamente,
your phone while driving? Ma ci vede curva, porco.
This is it? Getting a call. Let's see. Let's see. Gotta do this really quick thing. What is this? Oh, okay. Let me read this really quickly and then we'll keep going since we're almost done. Okay. just a whole bunch of things. Okay, whatever. Let's get it. Another sesh. Start.
Risk to an acceptable level. So collectively, as a group, we've decided or understood that we're not going to get our risk down to zero. So there is some acceptable level. So the security posture is what tools, what safeguards we put in place, processes and so forth, that will get us down to that acceptable level, understanding that it will never be down to zero. And then the risk exposure. So that is assessing and basically quantifying the existing risks and their potential impacts. And that's done through a myriad of different tools,
Bro, why
business
am I
impact
yawning like
analysis,
crazy, bro?
vulnerability analysis, some things that have been covered in other courses on how to quantitatively and qualitatively, objectively look at risk and say, okay, here's the risk, here's our actual potential to be exposed to it. And then if in fact it does occur, what's the maximum loss that we can expect? How many times per year could we expect to have this type of loss and so forth? So we can put all of those things together and give ourselves a risk exposure, assign it a number or a dollar value, right? It's going to be different for your individual organization, but assessing and quantifying that existing risk and their potential impacts allows us to then look at what tools are necessary to get us down to an acceptable level, right? We're going to mitigate that risk to an acceptable threshold. And then the risk posture itself defines it at a very base level. What's our typical go-to response when we do, in fact, encounter a risk? So looking at this holistically, let's look at the security cycle and take a few of these things piece by piece. So security cycle is there to protect assets. That's what drives revenue, and that's what brings value to the business, right? Our various assets. So assets are endangered by threats. Those threats are things that exploit weaknesses, right? Vulnerabilities in our infrastructure or our environment. That results in exposure, leading to risk, mitigated by some type of control. And then, of course, those controls are there to protect assets. So it kind of goes around in a circle. As we can see, it's a loop. All of those things are in place to mitigate risk to an acceptable level and to protect the assets that either drive revenue or help us maintain, avoid, or reduce cost. So the security cycle obviously applies to security controls and practices and so forth, but it also applies to compliance. So as we implement these various things to get us into compliance, we need to make sure that we take the same approach and keep the ethical mindset and the compliance mindset, have that built into the culture, which we'll talk about a little bit more in just a few, but keep that or ingrain that into the culture so that when we implement these different approaches to lock things down, secure our different assets and so forth, we're achieving two goals at the same time. We're actually securing the asset and we're also maintaining compliance in an ethical fashion. Okay, let's talk about managing risk. So there are multiple ways, obviously, of managing a risk. We can do one of several things. We can accept certain levels of risk, as I talked about. We understand it's never going to be zero. So we'll reach some type of posture and say, okay, we're going to accept this level or this threshold. We can also transfer risk and say, okay, we're not going to accept that. We don't want to necessarily take the burden of trying to constantly mitigate that ourselves. We'll transfer that, let's say, to a third party. We can also implement controls to reduce risk as much as possible. And then in some instances, we can avoid it altogether. So every company is different, and as such, each has a different tolerance for risk. And that's really what this boils down to is, what is your risk tolerance? So risk management can be defined really as the identification, the assessment, and the prioritization of risk, along with the mitigation and the monitoring of those risks. So as an example, when dealing with computer hardware and software, risk management is also known as information assurance, or you may see the abbreviation IA. And that will depend upon the company's risk tolerance, right? Your risk tolerance. And that can vary by industry, a government versus a tech startup as an example.
Wait a
Also
minute.
the value of the data that you're...
Hold up. Wait a minute. Do I have... Wait a minute. Wait one just minute. It is. Yo, that's crazy. That is crazy. Wait. Maybe not. No, it's gotta be. It looks exactly... I think it is, bro. Gotta be. It's literally gotta be. It literally is. How do I not have? Here, it's gotta be over here. That is crazy. It is, bro. Yup. That's crazy. I knew that shoreline from anywhere, bro. That's awesome. That's just funny. Alright, back to it. Back to it. It was just funny. It's just funny.
Protecting. If it's something that's maybe ephemeral, it's not going to last very long, or it's not a high value piece of data or data set, well, then you're not going to do a lot to protect that necessarily. If it's something that's extremely valuable, critical to your business, then you're going to invest time, resources, and so forth to make sure that that data is protected. And then lastly, the ability to actually recover that data. If it's something that can be easily regenerated, well, then the risk of it going away is not so high. Maybe the risk of it being stolen is great, but if it's capable of being recovered or regenerated quickly, then the controls in place to actually allow that regeneration to take place don't necessarily need to be as complex or perhaps as costly. So when we talk about risk management, several concepts I want you to be aware of, and that is the concept of risk transference. So if we transfer risk to a third party, as an example, right, we may insure our data center or insure some part of our business so that if disaster strikes, well, insurance will protect us, right? And all of these things kind of tie into compliance because a lot of these different things are components of being compliant with various regulations. So just if you're wondering where these things kind of tie together, all of these things go hand in hand. We have to make sure we're doing things in an ethical way. We have to make sure we're doing our business kind of in a standardized fashion across our footprint, whether we're in the US or the UK or anywhere abroad. And then we have to make sure that everyone is acting under the same guidelines. All right. And then next we have risk acceptance. So what's the cost of removing the risk versus dealing with the issue if and when it occurs, right? And that's what we talked about before. That's going to vary upon the type of data, how quickly it can be regenerated, recovered, and so forth, right? Is it business critical, or is the business necessary, or is it just something that's a nice to have, or perhaps even scratch data? And then risk mitigation and deterrence. So what level of reduction is acceptable, right? We talked about that risk posture. So what controls can be put in place to effectively minimize that risk? And then we also have something referred to as risk avoidance, right? She's very upset. She wants to avoid that risk at all costs. So many organizations will simply opt to not do something, deciding that the risk is too high. So an example might be deciding not to patch a certain piece of infrastructure. And you might say, well, why wouldn't we do that? Well, in some companies, in some environments, there is infrastructure that's been there for so long, it's been up and running and it's working. So it's like, if it's not broken, don't fix it. If there's a critical patch, well, that's a different story. But if it's just a patching just because it's Patch Tuesday and it's that time, well, we may not want to take that piece of infrastructure down because we're not sure if it's going to come back up again. So in certain cases, it may be better to not do something, right? How about migrating to a new platform? If the risks of migration are too great, there's a potential for downtime, and it's an application that needs to remain up at all costs, well, that risk might be too great at this point in time. So we're going to avoid that risk altogether. Also, perhaps launching a new site or a new service. If we're not ready, if we don't have the infrastructure, if we're afraid we're going to launch it and then it immediately crashes because we're going to get too much traffic and so forth, and then that will hurt our brand or our reputation, well, then that might be a risk that's worth avoiding at the moment. Kind of regroup and then come back with a different plan. So it all depends upon the situation, obviously, but risk avoidance is in fact a mitigation strategy that you can add into your overall processes. So some strategic options we can look at, or if you flow chart this out, right, we have something we need to understand how we're going to address this issue. So there's a risk that we've encountered. If we start left to right, we can go, should we avoid or terminate, share or transfer, reduce or modify, or accept or tolerate? All right, so let's expand this out a bit. Well, if we walk through this, if we avoid or terminate, if we say no, well, then the next thing is, do we share or transfer? If we say no, do we reduce or modify, and so forth. If we avoid or terminate and we say yes, well, then let's cease activities that create the risk. If we can do that, then it drops down into, isn't it acceptable, right? Is that an acceptable level of risk? And if it is yes, then say, okay, that residual risk will be monitored and we'll just accept it and just keep an eyeball on it. If we go over to share and transfer, again, if we decide that's the course that we want to go, we can say, okay, let's move that over to a third party, allow them to manage that risk. And same thing, is it acceptable? If so, yes, then we'll just simply monitor and go forward. And you get the idea. Same thing with reduce or modify and accept or tolerate, right? Each has its own yes or no fork, and we can make subsequent decisions based upon which way we choose. All right, so all of these things lead themselves when we're talking about actual security, when we're talking about compliance. The thing that we're driving towards, or the things that we're driving toward, are the three core principles of IT security at the end of the day. And that is confidentiality, integrity, and availability, otherwise known as the CIA triad. So everything that we do, right, this is what you learn kind of in Security 101. Security Plus, we cover this quite a bit in other security courses as well. This is the basic fundamental purpose of implementing security within our system. We want to make sure that our data is confidential, that it's available, and that the integrity is there so it's not tampered with. If we can do those three things well, then we're going to be in compliance probably 99% of the time. Because if in fact those things are done properly, right, and there's no breaches, there's no inappropriate access, there's no data unavailability, and so forth, the bulk of most compliance mandates will be met. So again, what is compliance? It is the adherence to a set of rules pertaining to people, process, and technology as it relates to policies, standards, regulations, laws, and so forth, right? Things we talked about before. And I mentioned it previously in other courses, but some examples of compliance frameworks. We have HIPAA, right? The Health Insurance and Portability Accountability Act. We have the GLBA, the Graham-Leach-Bliley Act. And the other is PCI DSS, the Payment Card Industry Data Security Standard. Now, these are all very structured, very detailed compliance frameworks. A single business can, in fact, fall under the purview of multiple different types of regulations depending upon where they do business within the world. There's two different types of security compliance drivers. There's legislative mandates, right? Things that must be done, and they are external to the organization. And then good business practices. That's what we should do or what should be done. And they're typically internal to the organization. So let's look at how these two things interact. So we have external requirements and we have internal requirements. External might be legislation like GDPR as an example, or various laws or policies throughout different parts of the world and so forth. Those things are all going to have external forces or external pressure on the company, and that's going to drive some of the internal requirements to make sure that they're actually complying with external requirements, right? So we have enterprise security management, have an overarching mandate or an overarching guideline. That's going to drive our enterprise security compliance requirements, such as policies, standards, procedures, and guidelines. Those things then have a direct impact on internal operations, security operations, and other operations. Again, they fall under that larger umbrella. The enterprise security compliance requirements also drive external operations as well, and how we deal with partners, how we deal with vendors, how we deal with contractors, customers, and so forth, right? So all of these things are done to, number one, make sure the business operates in a good fashion or in an ethical fashion, right? We're driving revenue and so forth. But then also make sure that we are in compliance with external factors that could, if not followed properly, have a very negative impact on our business, a risk as great, if not greater than any type of security breach, depending upon the severity of the non-compliance. And if it's an egregious event that keeps taking place over and over again, the fines could be so great that it could put a company out of business. So it's very important to take these things seriously and to devote the proper resources to make sure that they're actually adhered to properly. So just as I say in most courses, security is everyone's responsibility, well, compliance is also everyone's responsibility. However, chances are if everyone is responsible, then really no one is actually at the wheel, right? The assumption is, oh, somebody else is taking care of it. Because it's everyone's job, everyone thinks someone else is doing it. So while it's true that everyone should be responsible, we need to have someone or some group to actually be accountable. So we can drive into the culture that everyone is responsible, but we need to have someone at the wheel, making sure that our initiatives are driven properly and they're actually accountable for results. And we talk about compliance accountability, there are some questions that we should be asking, right? So does the enterprise footprint vary by geography? If so, then of course we're gonna have to adjust our compliance or make sure we're adhering to compliance regulations throughout the world. Do third parties around the world also create additional exposures? We may be dealing with supply chain in one part of the world that doesn't necessarily pose much risk, but supply chain in another part of the world might present significant risk, or some other type of contractor, right? You get the point. Depending upon where we are, don't take it for granted just because things flow smoothly in one part of the world, that they're going to flow smoothly in some other part. And then, are we monitoring pending changes to legislation, both locally and globally? Does this drill down to the state, province, or municipal level? Again, this revolves around having someone, some group, that is actually accountable for compliance. Everyone needs to be responsible. Everyone needs to do their part to make sure that they're operating in concert with each other, and we're all driving to the same goal. But somebody needs to be at the wheel. Somebody needs to be doing research, monitoring events, monitoring changes in legislation, and so forth globally to make sure that the company is in compliance. And then also, is compliance incorporated into 3- and 5-year business plans? If not, why? Are compliance trends also part of the growth calculations? So getting back to this responsible group, they need to be meeting regularly with executive management and with the board and making sure that everyone has that compliance mindset from top down. Right? It's not going to work from bottom up. It's got to be from the top, disseminated out to executive leadership, and then part of the actual culture. And then lastly, do we have visibility into emerging compliance risks and requirements? Are we taking a proactive or a reactive approach? We need to have that group that's proactively looking at all these things and staying one step ahead to make sure that compliance is at the forefront of everyone's thinking. So what this does is allow us to create a culture of compliance. So priorities are communicated from the top down, right? The board communicates to executive management. Executive leadership can then communicate down to everybody else. We have that top level buy-in, and we have that singular voice that is telling us what needs to happen and why. Then it can permeate throughout the organization. Couple that with continuous training and communication. Training is key. It's not a one and done. We have to constantly make sure that our employees are aware of what they do, how they do it, and why they're doing what they do. Let them understand how compliance factors into the big picture and how it makes it better for everybody. Again, an ethical compliance. And also continuous training. As new things emerge and as rules change, they need to be brought up to speed, and then also reinforce the things that they already know. In doing so, we make compliance a key component of training, performance metrics, mid-year, end-year reviews, and so forth. Again, boiling that in as a top-down approach puts it at the forefront of everyone's mind, and they incorporate that into everything that they do. Along those same lines, incorporate an individual's compliance responsibility into their actual job description. So that way they know day one, this is what's expected of me, and it just becomes the new normal. Okay, next up, let's talk about enterprise security frameworks, what it is. So an enterprise security framework, or an ESF, is a guide that we can use to create all of the documentation, the reporting, and so forth within our organization. Now, there are a number of free and existing guides already out there, so we don't have to start from square one. All right, so use existing guides where possible as a starting point. Again, a great example comes from the National Institute of Standards and Technology, or NIST. They have a publication, SP 800-53, that is a great guide to act as a starting point. All right, so it's recommended security controls for federal information systems and organizations, but it doesn't apply just to federal organizations. It's kind of the standard enterprise security framework that's used by organizations of all types, all sizes, not necessarily just federal organizations. Another good one is ISO 27001, 27002. Also COBIT, which stands for Control Objectives for Information and Related Technology. So there's a number of guides out there that gives us structured documentation around planning, assessments, and also monitoring. So these guides are very comprehensive, and in some cases they may not be comprehensive enough. It depends upon your organization, but at least it gives you a good starting point. So the NIST publication SP 800-53 is comprised of a number of categories, a number of families, and each of those families have a number of subsets or controls. So if we take a look at this, there are 18 different categories, or IDs: access control, awareness training, audit and accountability, and so forth, right? We can read through the list. Each of these are broken down into subsets that have definitions and parameters around each of these subsets, right? Each of these individual controls that you can then, as I mentioned, use to formulate your own enterprise security frameworks within your own organization. So let's take, for instance, we take one of these IDs, one of these families. If we break it down a little bit further, we can see security assessment and authorization, or configuration and management. Each of those has subsets. As an example, security assessment and authorization policies and procedures, or security assessments, or how about information security connections? If we further drill down, each of those has a number of processes and procedures that need to be followed or should be followed. Again, this is a guideline. It's not a hard, fast rule, but these are guidelines of best practices that should be followed to make sure that your organization is secure. And what this does is it allows you to provide due diligence and say, hey, we've done the research, we're following best practices, we have a guide in place that shows every aspect of our business, every aspect of our information security controls, our security posture, and so forth, and here's what we're doing to address any issues that may come up. Another good example is ISO 27001. It has similarly a number of different controls, a number of different IDs, or in this case references, and then a number of controls within each. So information security policies, organization of information security, human resources security, and so forth. And then each of these you'll see in parentheses is the number of controls that apply to that category. Again, a slightly different approach, but the same net effect. It gives us a guideline that we can use to formulate our own framework for our organization. So if we drill down as an example into, let's say, A9 access control, all right, it has 14 separate controls within that group. So if we take a look at that, under access control, these are all the different things, and each of these has additional parameters and additional guides and best practices under each of these topics that we can use to follow and draft our own documentation, our own policies, how we monitor things, and so forth. And then depending upon your organization and how you want to formulate your own plan, you may map one to the other. You may have NIST controls, or you may have the ISO 27001 controls, but you may have a plan, or you may be following compliance guidelines by some external regulation that says you need to map to one or the other. Well, you can show by saying, hey, under the category of least privilege, AC-6, under NIST, this is what I'm following. But it also maps to ISO 27001 under A.9.1.2, 9.2.3, and so on and so on. So you can show that you have controls in place that will put you in compliance with various regulations. Okay, so let's take a quick compliance example. back here at our good friends with Wired Brain Coffee. And what we're talking about is the need to ensure security controls are in place. So what do we need to do? Well, we want to do vulnerability assessments, a risk analysis, and a business impact analysis. Why? Because we have certain things documented within our enterprise security framework that covers various risks, various areas that we need to address. Within that, we're going to identify all critical business functions, systems, infrastructure, and so forth. Such things as our customer portal, payroll, billing, supply chain, and sales. Within that, we will identify what's critical. Out of those things, we've identified that, let's say payroll is our most critical function. So critical business function, payroll, what's the deal here? So we have 15 servers, we have 10 ESX hosts, and 5 physical servers. We have app and database servers. We also have SAN storage and backup. And then backups are replicated to an offsite location for resiliency, disaster recovery, and so forth. We're also responsible for maintaining and supporting applications. This includes maintenance and lifecycle patching, also securing. So with all of these objectives, we'll utilize our enterprise security framework and kind of chart out what our thought process should be. So I'll refer back to the previous chart that I had. So if we look at this in more detail, here we have our decision matrix, if you will, right? Our flowchart of how we should approach this task. We're talking about our payroll servers. What do we want to do? Well, going through our decision tree, we decided that we want to share or transfer. We're going to bring in some third-party contractors to basically man the ship, help us do patching and so forth, make sure that we have round-the-clock coverage, all of that good stuff. So there will be some residual risk, such as access control, making sure that the people who are actually working for us as third-party, that they're vetted, they have the proper security and so forth. We want to make sure we have access controls in place. But by having all of those things documented and called out in our enterprise security framework, we have hard, fast documentation that we are thinking of all these potentials. We have plans in place. We're showing what our level of risk tolerance is. And then we have mitigation steps in place, and then also contingencies when things go bad. So from a compliance perspective, we're kind of checking all the boxes. Plus, we're also strengthening our security posture because it forces us to think of things that we may not typically think of. So it's a great exercise to go through. Now, as I mentioned, the residual risk is always going to be there. We're never going to be able to get all of the risk completely down to zero. So residual risk remains. In this case, once the decision is made to transfer the business to third party, some residual risk remains. All right. So part of that will be assumption that the third party properly secures their infrastructure, that their people are properly trained and so forth. Right. So it's always going to be something. We have to make sure that we can maintain connectivity to the third party provider. Right. If that connection gets cut, how does that affect our ability to do business? It could be a cloud outage, it could be loss of connectivity, whether it be a fiber cut, ISP outage, and so forth. Once we've gone through all of these components, right, and we've kind of decision treed this thing out, the residual risk is then either acceptable or we have to go through another pass to try to mitigate further. So if we come up with something and say, hey, that maintain connectivity to a third-party provider, a cloud outage, well, I think we can mitigate that even further. How about if we split that between 2 clouds and now we have kind of cloud resiliency, or we have a second ISP that can provide connectivity. So in case fiber or connectivity gets cut from one provider, we can fail over to another, right? There's always a way to kind of whittle it down, but there are associated costs with that. So every time you go through and you mitigate, there is costs kind of go up. So there's a happy medium. There's a risk tolerance. So there's an acceptable threshold. Once that's there, put a fork in that one and then move on. So in this module, we covered a lot of good information, talked about ensuring compliance and security operations, talked about external factors such as legislation, policies, and so forth, talked about ways to define risk, also some compliance frameworks, such as what is an enterprise security framework, utilizing NIST SP 800-53, ISO 27001 or 27002, talked about using NIST as an enterprise security framework, and then an example scenario of how an enterprise security framework benefits the organization, how you can use that to help you define and make your decisions, and kind of walk through a little bit of a flowchart to make a decision on a specific security issue, evaluate what residual risk was left, and then determine a tolerable level of risk. So I hope this module was informative for you. I'd like to thank you very much for watching.
Finally, bro, this was so long. It was a good overview. But we'll be jumping, I think, more in depth into this stuff, and a lot of this stuff was reviewed. That's it? Okay. Next, knowledge check. Where are we with this, bro? Here. Assessment here. U.S. Federal Court of Last Resort is the Supreme Court, bro. Come on now. This one. Wait a minute, judicial. Yeah, it's this one, I think, actually. Review laws? Yeah. Because this one is this. Executive? Which branch is that? 3? Which Article 3? What did I just say? Article 3? Article 2? Article 2 is legislative, I think. Or is that? It's one of these two. Dang. Is it 2 or 3? I'm gonna take a shot at just one of them. What is a case of first impression? The first case that court hears when it is in session, a case that changes established precedent, a case for which there is no established precedent, Case that is appealed. I feel like this one makes the most sense. But I don't actually know the answer, but this one just makes most sense. So we'll just go with that. FTC is which type of federal agency? Oh, a congressional federal agency. The doctrine of precedent is also known as... Oh, bro, I don't remember that. What's the word? Are they saying like the Latin phrase or what? Bruh, I don't remember. Oh, dude. Come on now. Precedent. Lex scripta is code law. Lex non scripta is common law. Writ of certiorari is not that. What is it? I can't remember the Latin phrase. What's the Latin phrase for this? Precedent, doctrine of precedent. What's the other name for it? Bro, I don't remember. I'm just gonna take the L on that. I don't know. I can't remember. What is procedural law? Branches of that deal with property cases that set forth the structure of the judiciary system. Branches of law that deal with the following precedent. Branches of law that deal with processes the courts use to decide cases. D. What is common law? System of law inherited from England. System of law that relies on established legal principles and traditions. Both. A system of law that inherited from England and a system of... Probably this one. Compliance is blank, audit is blank. Compliance is following the rules. Audit is verifying that the rules are followed. Yeah. A. Federal agency is granted its authority by granted its authority by the Agency Act. What is that called, bro? I don't remember. This is gonna be wrong, bro, because I don't remember. Agency Act? Is it literally just called that? I don't know. Some sort of act. Agency Act of something. I don't know the direct name. Which U.S. Constitution clause describes Congress's authority to regulate trade between states? Which Constitution clause? The Commerce Clause. U.S. Supreme Court has 9 justices. How many reps are in the House of Representatives? Let's see, 435. There are blank federal district courts. 13? 12? Oh shoot, how many? 13 or 12? I think 13. $12 plus 1, I think it is 13. Okay, let's see what we got. Let's see what we got. Hopefully we did better last time. That's for sure. Chapter 3. Okay, we gotta zoom in on this. Where's the zoom? Okay, chapter 3. 1E. Oh shoot, let's go to the top. Bet, nice. 2B, nice. 3A, nice. 4D. I told you it was one of the two. Oh, and I just guessed wrong. If I just guessed right, then I would be that would be better. So So that means this goes to red. And this goes to green. To signify I got this one wrong. 5. 3. 5 is C. Nice. 6. Chapter 3, 6. A. What did I put? That there's D and E. It's independent. Am I in the right chapter? Yeah, American. 6. A. Dang. Okay. I guess it was established by Congress, though. An independent federal agency. Okay. I don't know what. I'm gonna review that because I don't even know what that means then. That's green. It's gonna be red. This one's automatically red because I didn't get it. I didn't even know. I didn't even know. Doesn't even, or no. Stare decisis. Yeah, that was the thing that I couldn't remember, but let's say red. And put the answer in here. Stare decisis. Decisis. Whatever. Save. I got that one wrong. Dang, that's tough. Ooh, that's hurting my score. 3. This one really, I should not have got. I knew this one, and the other one was a guess. If I get any other ones wrong, it's over for me. It's over. 8. D. Nice. 9. E. Nice. 10. A. Nice. 11. Congress. Oh, I got that wrong. Wait. 11. I don't even remember. Oh, by Congress. I put Agency Act. That's wrong. Dang. That's tough. Wrong. Correct is Congress. Dang, that's tough. 12. D. Nice. 13. 9. Nice. 14. C. Nice. 15. 94. 94 what? Oh. District courts. I was way off. Dang. Something else is 13 then. Dang, I did terrible. I got like 5 wrong. I did terrible. I got like a D on this. 1, 2, 3, 4, 5. Yeah, I got 10 out of 15, bro. But it literally does not matter. Next. Done. Okay, next. Next. Summary. Next. Section 3, laws influencing information security. Wait, I need to make sure, why isn't, sometimes these things don't like check, bro. Read, next. Section 3, and then there's section 4. This one's got a lot in it. This one's got the most, I think. Introduction. Prepare for the assessment. This section provides instruction to help you demonstrate Thus, 4 presents the information security challenge faced by the federal government and what regulatory processes are in place to address those challenges. Lesson 5 introduces a history of how states have protected personal information, including laws, state agencies, and regulations. Lesson 6 reviews the basics of American intellectual property law, such as patent, trademark, and copyright protection, as well as the Digital Millennium Copyright Act. Lesson 7 discusses contract law with special emphasis given to how the internet has affected how contracts operate. Lesson 8 contrasts a discussion of criminal law with that of tort law, and also discusses how each has been affected by the rise of the internet. A very interesting class. Prepare for the assessment. To prepare for the competency performance assessment, ask yourself these questions. What are the federal government's information security challenges, and how is privacy in government information systems protected? What are the requirements under the Federal Information Security Management Act, and what is the role of the National Institute of Standards and Technology in creating information security standards? How does the U.S. federal government protect privacy in information systems, and what are import and export control laws? What approaches do individual states take to protect the security of personal information? Okay, so this is after I finish this section, or before it, I don't know. Okay, what laws do certain types of data protect certain types of data? What are state breach notification laws? What are differences between state breach notification laws? Why is IP law important? What is the concept of legal ownership? How are patents, trademarks, and copyrights used, and what do they protect? What are the main internet-based intellectual property concerns? And what does the Digital Millennium Copyright Act protect? What are the main principles of contract law? How does contracting on paper differ from online contracting? What are the most common types of agreements, and what are end-user licensing agreements? Why is it important to include information security provisions in contracts? What are the common concepts in American criminal law, and how are they used to prosecute cyber criminals? What are the common concepts in American tort law, and how are they used in cyberspace? What are the differences between criminal and tort law? Okay, next. So look, it's not checking. Oh, it did. Nice. Move ahead if ready. Are you ready to demonstrate your competency and skills if you answered yes to assessment preparation questions? What is this? I need to do this first, no? This should be after this, no? Yeah, criminal law and tort law. Oh, okay. So it's just preparing me for this before I go into it. Okay. I mean, the way that it worded it sounds like that should be at the end. Introduction. Lesson 4. Lesson 4 looks at the challenges to information security faced by the United States federal government and how they are mitigated. Federal Information Security Management Act of 2002 is designed to protect the security of federal agencies' information technology. This act requires a review of security policies as well as mitigation plans through establishment of information security programs in terms of privacy protections. At the federal level, the U.S. depends on the Privacy Act of 1974 and the E-Government Act of 2002. Both of these acts specify how personal data is managed and direct how the public are informed about how data is collected. Two case studies illustrating the concepts in this lesson are provided in your reading. One on a missing hard drive at the National Archives and Records Administration, and the other relating to the social media use policy for Department of Defense employees. Next. See, look, that one didn't check. This one. Now it did. Learning objectives. Okay, this is what we're doing here. Supplemental videos, 12-minute and a 13. Okay, these ones aren't log. Oh, CIPP US Cert Prep Privacy Environment. Oh, just those two from the prep. Okay. Chapter 8. So we can create a new page then, because that's what we're doing here. Wait, that should just be here. Okay, templates, course section. Course. This one. Actually, we can do, this should open up, and we did that. Now we want to do this. Start. See, I want to start reading this, but I don't know. Maybe. I gotta at least start something with it. Like, I don't have to get far. Like, even if it's just a couple pages. And what'll be next? Federal government. This one. What is this called? Okay, I guess I could just copy that. Chapter 8 is that. Start. Guess just do that. Okay. So I guess we could just open up the other thing now then. What was the other one? This. Actually, we can now edit this. Because we don't do that no more. We do this. Okay, so we did this. We gotta start this though. Oh, I clicked the wrong link. Oh, this is just open here. No, I wanna open it here. This one. In here so I can annotate it. Is that the same thing? Oh yeah, I just deleted the first page, I think. Wait, what? Oh, I clicked the wrong thing. Here. I'm not even clicking the right link, bro. There we go. Yeah, here we go. So I got it. I did read this, though, I think. This is 150 pages, bro. I should restart it, though. Because I should have started this last week. And it's already the end of this week, so we're behind on that. It's a long one, but you gotta chip away at it. It looks like an important one. National Research Council. Advisors to the nation on science, engineering, and medicine, the National Academies. The National Academy of Science is a private, nonprofit, self-perpetuating society of distinguished scholars engaged in scientific and engineering research, dedicated to the furtherance of science and technology, and to their use for the general welfare. I need more water. Oh, I can't reach. Why is it getting dark already, bro? It's 4:30. I switched the red light. Switching red light. We already doing that. Already on that, bro. Okay. We can make it a little bit bigger, actually. Let's see. For their use to the general welfare. Upon the authority of the charter granted to it. Upon the authority of the charter granted to it by the Congress in 1863, the Academy has a mandate that requires it to advise the federal government on scientific and technical matters. Dr. Ralph J. Cicerone is president of the National Academy of Sciences. The National Academy of Engineering was established in 1964 under the Charter of the National Academy of Sciences as a parallel organization of outstanding engineers. It is autonomous in its administration and in the selection of its members, sharing with the National Academy of Sciences the responsibility for advising the federal government. The National Academy of Engineering also sponsors engineering programs aimed at meeting national needs, encourages education and research, and recognizes the superior achievements of engineers. Dr. C.D. Moat Jr. What kind of name? C.D. Moat Jr., like so many little... is president of the National Academy of Engineering. The Institute of Medicine was established in 1970 by the National Academy of Sciences to secure the services of eminent members of appropriate professions. In the examination of policy matters pertaining to the health of the public, the Institute acts under the responsibility given to the National Academy of Sciences by its congressional charter to be an advisor to the federal government and, upon its own initiative, to identify issues of medical care, research, and education. Dr. Harvey V. Feinberg is president of the Institute of Medicine. The National Research Council was organized by the National Academy of Sciences in 1916 to associate the broad community of science and technology with the Academy's purpose of furthering knowledge and advising the federal government. Functioning in accordance with general policies determined by the Academy, the Council has become the principal operating agency of both the National Academy of Sciences and the National Academy of Engineering in providing services to the government, the public, and the scientific and engineering communities. The Council is ministered jointly by both academies and the Institute of Medicine. Dr. Ralph J. Cicerone and Dr. C.D. Moat Jr. are chair and vice chair, respectively, of the National Research Council. Committee on Developing a Cybersecurity Primer, leveraging 2 decades of National Academy's work. David Clark, Massachusetts Institutes of Technology Chair, Thomas Burson, Anagram Laboratories, and Marjorie Blumenthal, Georgetown University. Staff: Herbert S. Lynn, Study Director and Chief Scientist, Computer Science and Telecommunications Board. Eric Whitaker, Senior Program Assistant, Computer Science and Telecommunications Board. The whole board here. Let's see what they got. They got University of Massachusetts Amherst, Google Inc., Columbia University, Bremer Tech, Apple, Georgia Tech, Alamaden Research Lab, Stanford, University of Pennsylvania, Carnegie Mellon, Google, Microsoft, U.S. Venture Partners, MIT, UVA, University of Virginia, MIT, University of Southern Cal, Berkeley National Laboratory, Preface. Today, cybersecurity is widely viewed as a matter of pressing national importance. Many elements of cyberspace are notoriously vulnerable to an expanding range of attacks by a spectrum of hackers, criminals, terrorists, and state actors. For example, government agencies and private sector companies, both large and small, suffer from cyber thefts of sensitive information, cyber vandalism, for example, defacing of websites, and denial of service attacks. The nation's critical infrastructure, including the electric power grid, air traffic control system, financial systems, and communication networks, depends extensively on information technology for its operation. Concerns about the vulnerability of the information technology on which the nation relies have deepened in the security-conscious environment after September 11, 2001 attacks, and in light of increased cyber espionage directed at private companies and government agencies in the United States. National policymakers have become increasingly concerned that adversaries backed by considerable resources will attempt to exploit the cyber vulnerabilities in the critical infrastructure, thereby inflicting substantial harm on the nation. Numerous policy proposals have been advanced, and a number of bills have been introduced in Congress to tackle parts of the cybersecurity challenge. Although the larger public discourse sometimes treats the topic of cybersecurity as a new one, the Computer Science Telecommunications Board of the National Research Council has long recognized cybersecurity as a major challenge for public policy. CSTB work in cybersecurity over more than 2 decades offers a wealth of information on practical measures, technical and non-technical challenges, and potential policy responses. Produced by the Committee on Developing a Cybersecurity Primer, leveraging 2 decades of National Academy's work, the present report draws on past insights developed in this body of work to provide a concise primer on the fundamentals of cybersecurity and the nexus between cybersecurity and public policy. This report is based primarily on earlier CSTB work, and for readability, direct extracts from that work are not set in quotation marks, nor are passphrases from that work identified as such. Paraphrases. Report is based primarily on earlier piece of work. Okay, but it's not set in quotations nor paraphrases. Okay. However, the report is also addresses issues not covered in the earlier CSTB work, and the committee acknowledges with gratitude input from William Press at UT Austin, Tim Gibson at Draper Labs, Stephen Savage at UC San Diego, and William Sanders, University of Illinois at Urbana-Champaign. Finally, we see U of I also got to worry about that there's no participation from them, okay, and a variety of cybersecurity-related topics in the course of its work. As a primer, this report presents fundamental concepts and principles that serve as points of departure for understanding specific cybersecurity incidents or proposals to improve security. The specifics of cybersecurity change rapidly, but the fundamental concepts and principles endure, or at least they change much more slowly. These concepts and principles are approximately independent of particular cybersecurity technologies or incidents, although they manifest themselves in a wide variety of different technologies and incidents. The report's emphasis on fundamental concepts and principles also means that in the interest of brevity, coverage in this primer cannot be comprehensive. For readers who wish to explore particular topics more deeply, the detailed CSTB report listed in Appendix B provide a substantial resource. Box P1, Selected Computer Science and Telecommunications Board Work on Cybersecurity, a brief summary of the highlights. In 1991, CSTP report Computers at Risk warned that as computer systems become more prevalent, sophisticated, embedded in physical processes, and interconnected, society becomes more vulnerable to poor system design and attacks on computer systems, and that the nature and magnitude of computer system problems are changing dramatically. It also lamented that known techniques are not being used to increase security. In 1999, CSTP released Trust in Cyberspace, which proposed a research agenda to increase the trustworthiness of information technology, IT, with a special focus on networked information systems. This report went beyond security matters alone, addressing as well other dimensions of trustworthiness, such as correctness, reliability, safety, and survivability. Importantly, it also noted that economic and political context is critical to the successful development and deployment of new technologies. In 2002, CSTB issued Cybersecurity Today and Tomorrow, Pay Now or Pay Later, which reprised recommendations from a decade of CSTB cybersecurity studies. Its preface noted that it is a sad commentary on the state of the world that what CSTB wrote more than 10 years ago is still timely and relevant. For those who work in computer security, there is a deep frustration that research and recommendations do not seem to translate easily into deployment and utilization. CSTB's 2007 report toward a safer and more secure cyberspace observed that there is an inadequate understanding of what makes IT systems vulnerable to attack, how best to reduce these vulnerabilities, and how to transfer cybersecurity knowledge to actual practice. It set forth an updated research agenda, sought to inspire the nation to strive for a safer and more secure cyberspace, and focus substantial attention on the very real challenges of incentives, usability, and embedding advances in cybersecurity into real-world products, practices, and services. In 2009, CSTB turned its attention to the technical and policy dimensions of cyber attack, the offensive side of cybersecurity. Technology, policy, law, and ethics regarding U.S. acquisition and use of cyber attack capabilities concluded that although cyber attack capabilities are an important asset for the United States, the current policy and legal framework for their use is ill-informed, undeveloped, and highly uncertain, and that U.S. policy should be informed by an open and public national debate on technological, policy, legal, and ethical issues posed by cyber attack capabilities. In 2010, the CSTV report toward a better usability, security, and privacy of information technology report of a workshop identified research opportunities and ways to embed usability considerations in design and development related to security and privacy. In that year, CSTV also produced a second workshop report, Proceedings of a Workshop on Deterring Cyber Attacks, Informing Strategies and Developing Options, a collection of papers that examined governmental, economic, and technical, legal, and psychological challenges involved in deterring cyber attacks. Project Statement of Task, a primer on the technical and policy issues of cybersecurity building on more than 2 decades of prior Academy's work, will be developed under the auspices of a small study committee. The report will examine what is known about effective technical and non-technical approaches, the state of the art and open challenges, why relatively little progress has been made in cybersecurity despite the recommendations of many reports from the academies and elsewhere, and potential policy responses. Much of the material will be drawn directly from previous reports. The committee will also review emerging issues and new technical and non-technical approaches that may not have been covered in a previous National Research Council reports. Acknowledgement of reviewers. This report has been reviewed in draft form by individuals chosen for their diverse perspectives and technical expertise, in accordance with procedures approved by the National Research Council's Report Review Committee. The purpose of this independent review is to provide a candid and critical comments that will assist the institutions in making its published report as sound as possible, and to ensure that the report meets institutional standards for objectivity, evidence, and responsiveness to the study charge. The review comments and draft manuscript remain confidential to protect the integrity and deliberative process. We wish to thank the following individuals for their review of this report. Columbia University, Caltech, Harvard Law School, University of California, Berkeley, University of Virginia, Microsoft Corporation, Conway Computer Corporation. Although the reviewers listed above have provided many constructive comments and suggestions, they were not asked to endorse the conclusions, nor did they see the final draft of the report before its release. The review of this report was overseen by Sam Fuller at Analog Devices, appointed by the National Research Council. He was responsible for making certain that an independent examination of this report was carried out in accordance with institutional procedures, and that all review comments were carefully considered. Responsibility for the final content of this report rests entirely with the authoring committee and the institution. Contents. I kind of want to, should I do a stream where I just brute force this whole article? Just call it Reading 150-page Cybersecurity Policy or documents. And just do a whole thing on that, just read it straight through. And notes, annotate it. The whole thing. That'll be tough, bro. It's worth like 100 pages. Let's see. Why I care about cybersecurity? Basics of computing and communications tech and their significance for cybersecurity. Computing technology, communications technology and the internet, IT systems. On the nature of cybersecurity, terminology of discussions of cybersecurity and public policy, what it means to be an adversary in cyberspace, cyber exploitation, cyber attack. I'm not gonna like take notes of this, but I will mark it up. I'll annotate it, but not like separate notes. The anatomy of adversarial activities in cyberspace. Oh, here. Inherent vulnerabilities of IT. The anatomy of adversarial activities in cyberspace. Cyber penetration, cyber payloads, operational considerations. Characterizing threats to cybersecurity, threat assessment. Enhancing cybersecurity approaches to improving security, reducing reliance on IT, knowing that security has been penetrated, defending a system or network, ensuring accountability, building a capacity for containment, recovery, and resilience, employing active defense, non-tech dimensions of cybersecurity, economics, psychology, law, organizational purview, deterrence, assessing cybersecurity on the need for research, tensions between cybersecurity and other public policy concerns, economic approaches to enhancing cybersecurity, economic impact of compromise in cybersecurity, innovation, civil liberties, privacy, free expression, due process, international relations and national security, internet governance, reconciling tensions between cybersecurity and surveillance, norms of behavior in cyberspace, managing the global supply chain for information technology, role of offensive operations in cyberspace, findings, conclusion. Not bad. Oh, this doesn't have table of contents. That sucks. I don't know, should I start this? Or should I do a stream where I just read the whole thing like tomorrow? I think it would be like way better to just read the whole thing, brute force it, because otherwise it'll take forever to read it piece by piece. Right? That's what I'm thinking. Plus that would be a good stream, is to go through the whole thing rather than have this piece field. How long would it even take to read this whole thing? I don't know. Yeah, I think that's what I want to do. What if I do that tomorrow? Brute force this whole thing. Wake up tomorrow, get some coffee, breakfast, and then just get started on this. I feel like if I start on this in the morning, like it's not gonna take the whole day. It'll take a long time, but it not that long. Depending on how long it takes for me to just highlight stuff, but yeah, I'm gonna do that. I like that. I like that idea way better. And that way today I can just get started on the textbook notes. Yeah. So I kind of started this. I read a little bit up to the summary. So now I want to do this. Okay, I'll just start on chapter 8 instead, and then get into this. Okay, cool. Yeah, I'm gonna do that. That's what I'm gonna do. So and then I'm gonna start on chapter 8. That way I don't have to like finish chapter 8. I can at least start it, and then tomorrow when I finish the document, I can continue on chapter 8, and it's like it's already been started. That would be good. That would be really good. Yeah. Yeah, that would be nice. So that's what I'm gonna do. Don't need that, so we'll just start with this. That means here we can, what about this? I wanna read this at some point. Dang, there's so much, bro. But let's just get started with this. What is this? Part 2, laws influencing information security. Yeah, we're skipping a lot of these and just getting into it. 4, 5, 6, 7. Do we just not do that? Is it in this section? 4, 9, 10. Wait. No, we just skipped those. Nice. I guess whatever then. Yeah, we're not going to be doing that. That's fine. I'll just go straight to this. Chapter 8. Are there goals for this section? Yeah. Federal government, information security, and privacy regulations. In a 2009 speech, then U.S. President Barack Obama said that America's digital infrastructure is a strategic national asset. He urged a broad plan to protect the security and privacy of federal information systems, stating that the nation's digital infrastructure must be better protected. Both the federal government and private organizations have a role to play. This chapter reviews how the federal government protects its information systems. These systems hold personal data about U.S. residents, conduct the business of running the country, hold sensitive security data, and are used for the nation's defense. This chapter reviews the security and privacy laws that protect these systems. Chapter 8 Topics covers the following topics and concepts: what the information security challenges facing the federal government are, what FISMA does, how federal government protects privacy in information systems, what import and export control laws are, case studies and examples. Describe the role of NIST in creating information security standards. Discuss approaches to protecting national security systems. Describe how the U.S. federal government protects privacy in information systems. Review import and export control laws. Okay. Jeez, 900 pages. What is this actual? How many pages is this, like, book? Let me look at this web version of it. $7.85. What if I, like, look at the physical version? How many pages is it? Yeah, this is it. 552. That's crazy. We'll start this. We'll go hard once we hit the 30-minute break. We'll use that 30-minute break session for Try Hack Me. What is cyber war? U.S. Secretary of Defense Leon Panetta stated that attacks on the nation's critical infrastructure could be a cyber Pearl Harbor, an attack that would cause physical destruction and the loss of life. Many people worry about cyber war or information warfare. However, cyber war does not take place on a physical battlefield or on the sea or in the air. Instead, it is a conflict that takes place in or purposely affects information systems. The term cyber war refers to conflicts between nations and their militaries. Cyber war attacks are carried out at the direct direction of a particular nation. This is the main distinction between cyber war and other types of information system attacks that are reported in the news media. Cyber war could affect military information systems, non-government information systems, and private industry information systems. It includes not only threats to national security, but also threats to industry, commerce, IP. It could even include larger threats on how governments function generally. Consider these examples. Why does my water bottle smell like tea when I only have water in here? Am I tweaking? Maybe I'm tweaking. Just water. Like not actually maybe I don't need any of this. Thought maybe this would be interesting, but after reading it, not that crazy. This chapter focuses on how federal government protects its IT systems and discusses many of FISMA's provisions. You should be aware that this area of law is complex and changes often. Or I feel like this, I should just I already have a FISMA. Like, if I think I already have a FISMA, what does that look like? just add sections to here probably. Dude, my hand is like cramping from holding this mouse, bro. Like this whole week. That's like, it's distracting me from being able to focus because I don't know what to do with my hand, bro. I've looked, I found this on my desk and I'm like playing around with this now. I'm like not even touching my mouse. I've just been sitting here because I was watching the video, so I wasn't even holding the mouse. Just gotta. Oh, I got 20 seconds until the break. Let's see, what do I want to, I think sure, I feel like I should just add overwrite whatever is 30-minute break right now already. Yeah, what I'm gonna do is I'm just gonna overwrite this whole section because this, hold on, this goes to here, goes to here. This should not be even named that, but I'll go back and rename different stuff. Okay, that's the link I just added. This one is here. Yeah, that's what I'll do. But we got a 30-minute session for 30-minute session for try hack me. so we'll do that. We could start. Let's do it. Okay. We'll start the resume learning. What is networking? This is gonna be a lot of review stuff since I already did A+ and whatnot, but it's good. It's good to do this anyway, but better to do it earlier than later because I want to.
Hey everyone, welcome back to another video here on Try Hack Me. Today we're going to be taking
This is a 23-minute one. Okay, these are not actually short. I thought these were gonna be short.
a look at the room. What is networking? Begin learning the fundamentals of computer networking.
Wait, what? To access materials, start machines, answer. Okay, join. Okay, join.
In this bite-sized and interactive module. This is a really cool module. This is, I believe, had some new technology introduced into it by our developers. Very excited to go through this, and it should be a nice one. Let's go ahead and dive into task 1. What is networking? Networks are simply things connected. For example, your friendship circle. You are all connected because of similar interests, hobbies, skills, and different sorts of things. And this is sort of where the term networking comes from if you are doing job hunting or other things like that, is you know someone who knows someone, things like that. Networks can be found in all walks.
Is this guy just doing the whole room? Task 3? He's just doing the room. I don't want to watch someone do the room. I want to do the room. Is this what I... Do I have to watch this? Bite-sized and interactive module. I don't think I have to watch the video. He's literally just doing the room. Task 1, he's going through it. Nah, I want to do it myself. Okay. What is networking? Networks are simply things connected. For example, your friendship circle, you're all connected because of the similar interests, hobbies, skills, and sorts. Networks can be found in all walks of life, public transport system, infrastructure such as national power grid for electricity, meeting and greeting your neighbors, postal systems for sending letters and parcels. But more specifically in computing, networking is the same idea, just dispersed to technological devices. Take your phone as an example. The reason that you have it is to access things. We'll cover how these devices communicate with each other and the rules that follow. In computing, a network can be formed by anywhere from 2 devices to billions. These devices include everything from your laptop and phones, security cameras, traffic lights, and even farming. Networks are integrated into our everyday life, be it gathering data for the weather, delivering electricity to homes, or even determining who has the right of way at a road. Because networks are so embedded into the modern day, networking is an essential concept to grasp in cybersecurity. Take the diagram below as an example. Alice and Bob and Jim have formed their network. We'll come back to this later on. Networks come in all shapes and sizes, but it's something that we'll also come on to discuss throughout this module. What is the key term for devices that are connected together? Now that we've learned what a network is and how one is defined in computing, just devices connected, let's explore the internet. The internet is one giant network that consists of many small networks within itself. Using our example from the previous task, let's now imagine that Alice made some new friends named Zane and Toby that she wants to introduce to Bob and Jim. The problem is that Alice is the only person who speaks the same language as Zane and Toby, so Alice will have to be the messenger. Because Alice can speak both languages, they can communicate to one another through Alice, forming a new network. The first iteration of the network was with the ARPANET project in the late 1960s. This project was funded by the United States Defense Department and was the first documented network in action. However, it wasn't until 1989 when the internet as we know it was invented by Tim Berners-Lee by the creation of the World Wide Web, WWW. It wasn't until this point that the internet started to be used as a repository for storing and sharing information just like it is today. Let's relate Alice's network of friends to computing devices. The internet looks like a much larger version of this sort of diagram. Network 1, Network 2, Network 3, the internet connects them all together. As previously stated, the internet is made up of many small networks joined together. These small networks are called private networks, where networks connecting these small networks are called public networks or the internet. So to recap, a network can be one of two types: a private network, a public network. Devices will use a set of labels to identify themselves on a network, which we will come onto in the task below. Who talks like that? We will come onto. Who invented the World Wide Net? Is it right? Yeah, correct. Next. Whoa. That's a big old section. Identifying devices on a network. To communicate and maintain order, devices must be both identifying and identifiable on a network. What use is it if you don't know whom you're talking to at the end of the day?
Of life. A city's public transportation system, the London Tube is a great example of this because it is a very well interconnected network, and it's a very big one too. Infrastructure such as the national power grid for electricity, another very important network. Meeting and greeting your neighbors, again, more of a safety network in that case. The postal system for sending letters and parcels, and so on and so forth. forth. You can see networks everywhere in your life, and they're very, very important concepts. But more specifically, in computing, networking is the same idea, just dispersed to technological devices. Take your phone as an example. The reason that you have
Alright, so I forgot to pause this thing for my try hack me, so I'm just gonna like finish this room, I guess. But I'm getting sidetracked with this task here now, so okay, how do I do this? Let's ink here. Nonsense. Good. What's this? This one's good. That's what I'm talking about. Oh, I'm fighting this traffic violation. Complete, not even. Wait, let me read this. Okay, I mean we're completely doing something sidetracked now. But we gotta take care of this because I'm not gonna stand with this. Now we're gonna research law, traffic violation law, because I'm not dealing with this. Okay. Wait a minute. Maybe I shouldn't do this though on stream. don't know nothing about this, bro. I'm Google, bro. What is prima facie? What? I didn't want to do that. I wanted to do this. Law, Cornell. What is this? Get out of here. As an adjective, prima facie describes a fact or presumption that is sufficient to be regarded as true unless otherwise disproved or rebutted. Prime example of the adjective use of prima facie would be prima facie evidence. When used as an adverb, prima facie means that it is regarded as true on first appearance but subject to additional examination or investigation. The main example of the adverb would use. In a civil and criminal law context, phrase usually suggests that a legal claim has adequate evidence so that it is reasonable for the court to proceed into trial or judgment. However, it can likely be hasty and irrational to make a final judgment only on a prima facie examination. In most cases, the party that brings the case, usually the plaintiff in civil cases, the prosecutor, has the burden of proof. The party with the burden of proof introduces prima facie evidence for each element of the crime. Okay. What do you mean? Oh, here, ordinances. That's not even it. Oh, here. 2768. Oh, that's not even it. What is this? Why does it only go down to this? This is an infraction, not a civil trial. What would this be? Oh, here, administrative. Agencies? So is this because a police department's an agency of the executive branch? I don't know. Is traffic violation what type of procedural law is a traffic violation of this? The civil thing. No. Okay, so it's a civil. So the burden of proof is by a preponderance of the evidence. Oh, here I can look. This is what's going to be important to look at. Oh, alright, well, I'm going to go on break for now because this is not. I'm gonna get back to this thing because that's what I was supposed to be doing, and now I lost my time on this and everything. Identifying devices on our network. Okay, I read that. Devices on a network are very similar to humans. The fact that we have two ways of being identified: our name, our fingerprints. Now we can change our name through deed poll, but we can't, however, change our fingerprints. Every human has an individual set of fingerprints, which means that even if they change their name, there is still an identity behind it. Devices have the same thing, two means of identification, with one being permeable. These are an IP address, a media access control address. IP address, briefly an IP address for Internet Protocol, can be used as a way of identifying a host in a network for a period of time when the IP address where that IP address can then be associated with another device without the IP address changing. First, let's split up precisely what an IP address is in the diagram below. An IP address is a set of numbers that are divided into 4 octets. The value of each octet will summarize to be the IP address of a device on the network. This number is calculated through a technique known as IP addressing and subnetting. But that is for another day. What's important to understand here is that the IP address can change from device to device, but cannot be active simultaneously more than once within the same network. Should I resume? I should resume that. Even though I lost time. I lost like 10 minutes on this. I don't even know. IP addresses follow a set of standards known as protocols. These protocols are the backbone of the networking and force many devices to communicate in the same language, which is something that we'll come on to another time. However, we should recall that devices can be on both a private and public network. Depending on where they are will determine what type of IP address they have, public or private addresses. Public address is used to identify the device on the network, whereas a private address is used to identify a device amongst other devices. Take the table and screenshot below as an example. Here we have 2 devices on a private network. These 2 devices will be able to use their private IP address to communicate with each other. However, any data sent to the internet from either of these devices will be identified by the same public IP address. Public IP addresses are given by your internet service provider at a monthly fee, your bill. As more and more devices become connected, it is becoming increasingly harder to get a public address that isn't already in use. For example, Cisco, an industry giant in the world of networking, estimated that there would be approximately 50 devices connected to the internet by the end of 2021. Enter IP address versions. So far, we have only discussed one version of the internet addressing scheme known as IPv4, which uses a numbering scheme of 2 to 33rd IP addresses. So you can see why there is such a shortage. IPv6 is a new iteration of the Internet Protocol addressing scheme to help tackle this issue. Although it is seemingly more daunting, it boasts a few benefits. Supports more and more efficient due to new methodologies. The screenshot below compares IPv6 to IPv4. MAC addresses. Devices on a network will all have a physical network interface, which is a microchip board found on a device's motherboard. This network interface is assigned a unique address at the factory it was built at called MAC address. MAC address is 12-character hexadecimal number, a base 16 numbering system used in computing to represent numbers. Split into 2s and separated by a colon. These colons are considered separators. For example, the first 6 characters represent the company that made the network interface, and the last 6 is a unique number. Vendor who build the network interface in this instance, Intel, and unique address of the network interface. First 6 represent the company that made the interface. The last is a unique number of that. However, an interesting thing with MAC addresses is that they can be faked or spoofed in a process known as spoofing. This occurs when a network device pretends to be identifying as another using its MAC address. When this occurs, it can often break poorly implemented security designs that assume the devices talking on a network are trustworthy. Take the following scenario. A firewall is configured to allow any communication going to and from the MAC address of the administrator. If a device were to pretend or spoof this MAC address, the firewall would now think that it is receiving communication from the administrator when it isn't. Places such as cafes, coffee shops, and hotels alike often use MAC addresses, MAC address control when they when using their guest or public Wi-Fi. This configuration could offer better services, i.e. faster connection for a price if you're willing to pay the fee per device. The interactive lab attached to this task has been made to replicate this scenario. Practical. The interactive labs simulate a hotel Wi-Fi network where you have to pay for this service. You'll note that the router is not allowing Bob's packets, blue, to the TryHackMe website and is placing them in the bin. But Alice's packets, green, are going through fine because she has paid for Wi-Fi. Try changing Bob's MAC address to the same as Alice's to see what happens. Deploy the interactive lab to proceed to answer the following questions. Okay. Nice. Request site. Blue, blocked, trash. Not allowed. You can't go, you can't go. I'm trying to get in. Let me in, let me in. Oh, I can just change it. What does the term IP stand for? Internet Protocol. What is each section of an IP address called? I forgot what it was called. It's called a how many? 1, 2, 3 quartet or something? Octets. Quartets. Octets. No? Octet. How many sections and digits does an IP address? How many sections? 4. What does the term MAC stand for? Media Access Control. Deploy the interactive lab using the view site button and spoof your Mac to be accessed. What is the flag? Okay, so I'm just gonna copy this and then paste it and request. Now I get in, yay! Easy. Ping. Ping is one of the most fundamental network tools available to us. Ping uses ICMP, Internet Control Message Protocol packets, to determine the performance of a connection between devices. For example, if the connection exists or is reliable. The time taken for ICMP packets traveling between devices is measured by ping, such as in the screenshot below. This measuring is done using ICMP's echo packet and then ICMP's echo reply from the target device. Pings can be performed against devices on a network. Pings can be performed against devices on a network, such as your home network or resources like websites. This tool can be easily used and comes installed on operating systems such as Linux and Windows. The syntax to do a simple ping is ping IP address or website URL. Let's see this in action in the screenshot below. Here we are pinging a device that has private address of 192.168.1.254. Ping informs us that we have sent 6 ICMP packets, all of which were received with an average time of 4.16 milliseconds. Now you're going to do the same thing to ping the address of 8.8.8.8 on the deployable website in this task. Pinging the correct address will reveal a flag to answer the following questions below. Here. What do you want me to ping? This one? We're just gonna finish up this lab because we kind of ran through that time when I got interrupted a bit, so I'm gonna just keep going until I finish this since I'm almost done anyway. And I lost the time, so technically I would still be going. Ping the address of 888. 8.8.8.8. Answer the question, what protocol does ping use? ICMP protocol, bro. What is the syntax to ping? Ping 10.10.10.10.10. What flag do you get when you ping that? This one. Easy. I have both of these open. How do you close these, bro? Continue your learning by joining the Intro to LAN room. Oh, that was it? What is this? Get out of here. It's not a free room? Dashboard. View path. That's a premium room? It doesn't say anything. I thought this was free. I thought like this path was free, pre-security. That's gay. Oh, do I have to leave this first? Here. Free roadmap. Oh, intro to LAN is not on here. Where's the pre-security? Premium roadmap. Pre-security, oh. This is a premium roadmap. How was I able to do all these? So I can't even do this, bro. How come it doesn't say anywhere that this is not free? I mean, only here. Okay, whatever. So go back to the free roadmap. So this one, now this one I want to do. Oh, because not what is networking is in here. Yeah, I'm not paying for this, bro. But at least I could do all these. And I could do this. Alright, that's enough for this, I suppose. Because I did it. Nope. This, I'm gonna go here. Did my try hack me? Where is it? Try hack me room. Done. Did it. I did it. Oh, my hand is freaking. I think I'm gonna end the stream for now. Let's see, what was this? 4 hours, 20 minutes? I got a couple things done. Not really that much. I might come back to this a little bit later today.